regard to item 4, my lord, I just want 1 week time to get certain instructions.
17 matter.
Yes, I'm conscious of that. I was telling to my learned friend also. I don't have
What
the instruction, my
instructions?
lord. Within 1 week, if I get something, otherwise, my lord, I'd like
What
to
instructions do you want? Is there
know
any?
whether they have settled the matters or
The issue is regarding settlement of the insurance claims. Substantial claims have been settled by them. There is a last list of claims that has not been settled. If that claims are settled, we could have also closed this matter.
Well, what
That
is the
where it remains only.
position of the rest of the cases, my lord?
This is the only thing that
Difficult to adjourn 17 matters.
My lord, I'm conscious of that, my lord, since 17 matters. But then let me
Three
get
S. Datta, learned senior counsel for the respondent numbers 2, 3, and 4 has prayed for an accommodation to enable him to obtain instructions regarding any further development towards settlement of the claims.
insurance claims.
3. A. Sharma, learned counsel for the petitioner, is present. Para? Considering that the writ petition is a long pending one, comma, as an exceptional case, a week's time is granted to enable seeking of instructions. Para? List on, we'll have it on 21st of July,
so obliged.
21/7.
May I please? Lordship, I beg to mention item number 45.
Yes.
In this hearing, but in this case, last occasion, Honorable Court directed me to obtain instruction with regard to the board decision.
With regard to the
Board decision.
board decision.
Board decision. Lordship, I'm waiting for instruction. Lordship, 10 days time.
45.
Assam Mineral Development.
Also 19 matter.
Lordship.
We cannot adjourn 19 matters.
So in this case, that decision is necessary because in this.
If you are not being able to produce the decision, should we wait for an indefinite period? You are saying it is necessary. Why didn't you produce it?
Lordship, it was the.
What is this kind of submission is necessary? So we should adjourn. Is it a matter filed yesterday?
No, my lord.
7 years have passed.
Lordship, because this issue popped up in last.
Sorry. We're not adjourning.
Lordship, otherwise.
We do not know otherwise what will happen. 17, 19 matter is not adjourning. Don't ask for adjournments of all matters.
May it please, Your Lordship. Lordship, I beg to mention an urgent matter for motion.
When?
Tomorrow, Lordship.
Okay.
Deeply.
Item number 21.
Item number
21.
21. Yes.
The sole respondent in this case, Lordship, I need to file an affidavit. So 1 week time may be granted to.
But these are connected. Item number 20?
21.
Or not 20. Okay. 21.
This full municipal board versus.
Okay.
Assam. I have taken consent from. the
Mr. Roy.
side.
Lordship.
Okay. On a request made by Miss, what is your name?
KLR Yankan.
Please give your name. Learned counsel appearing for the sole respondent. 3 weeks time is granted to file affidavit in opposition. Para? Sri S.S. Roy, learned counsel for the petitioner, is present.
There's an interview.
List on. Today is 16th. 1, 2, 3. We'll have it on 10th of August. 10th of August. Interim order is there.
Yes, Lordship. Can it be on 12 or 13, Lordship?
12 August. 12 August. Interim order passed earlier to continue till the next date of listing.
Obligement.
I'm praying for listing of a matter, my lord. Contractor's bill, my lord. Work was executed in 2016, my lord.
Matter of which year?
Matter of which 2025, my lord.
25. Sorry, until the urgency is there. Order matters we are not.
My lord, already service is complete. my
We
lord.
don't know.
have
You
declared,
approach
my
the
lord.
registry.
Affidavit has been.
Mention memo only for urgent matters and motions.
My lord.
Yes.
May I please, Lordship. Item number 10, my lord.
Item number
10.
10 years.
Yeah. Maybe some accommodation of 10 days or.
You on behalf of whom?
Yeah.
Petitioner.
Yes, sir.
Inform the other side.
Yes, sir.
On a request made on behalf of the petitioner, matter is adjourned to be listed on 31st of July.
Interim order was there.
Interim order passed earlier to continue till the next date of listing.
Obliged.
May I please your lordship? Lordship, I beg to mention item number 17, lordship.
17.
Yes, lordship. With the consent of other side, lordship, kindly matter will be adjourned for a day, lordship.
Here for whom? The petitioner?
Yes, lordship.
When do you want?
Uh,
Why are you seeking time?
lordship, there's some personal difficulty, lordship.
Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed on 31st of July.
Highly appreciated.
Not 31st. Why should we give 30? On 24th of July.
Highly appreciated.
Lordship, I appear for all this.
Ms. S. Kotoki, let it, Standing Council ECI is present 24/7.
Okay.
May I please tell Lordship, I would like to mention for listing,
Listing.
this is a WBC.
Fresh matter.
This is urgent matter.
Is it a fresh matter, motion matter?
Not admission matter.
Admission, what is the urgency?
My lord, someone using my PAN card already taken 4 types of loan, four loan.
What is the urgency? We are not in the facts. What is the urgency?
My lord,
It has to be taken up tomorrow.
I have needed loan.
Sorry.
urgently.
Yes.
I beg to mention for listing of, it's a case matter.
When? Tomorrow. Okay. Have you filed or not?
Already filed.
Okay. Yes.
May I please your lordship? Lordship, with the consent of the other party, I beg to mention for item number 11.
11, yes.
Lordship, may it be adjourned for 3 weeks as we need time to file rejoinder.
Okay. What is your name, madam?
MD.
On the request of Miss M.D. Learned Counsel for the petitioner, matter is adjourned by 3 weeks to enable filing of rejoinder affidavit. Put stop. Para. List on 7th of August.
7. Obliged, lordship.
Yes. Yes, Mr. Gogoi, any development?
Name report as per the, on the other occasion, whether they place on behalf of the CBC. But there is the approval letter, there is the report.
What about the note sheets?
Note sheets, my lord, they say, my lord, over, these are communication, my lord, which have been, interchange between the department. And
Now,
they
how did it
mention
move? The file has to move in accordance with some notings.
That perhaps, my lord, has not been furnished, but I.
Then we'd have to proceed on the basis that it is not existing.
Yes. Presumption has to be done.
But my lord, the.
See, without a note sheet, a file cannot move.
No, my lord, so far as the, my lord, CBC note record is concerned.
Evidence.
it's there.
That we have seen.
Yes, it is there. And my lord, the approval of the government is there. That election 9 million. Same, my lord, documents, as is there in the report.
Then it is okay
Yes.
if there is no, if there, those are not different papers.
So even then, my lord, lordship will see the approval of the government regarding the revised proposal, as well as, my lord, the direction. of
Mr.
the
Gogoi,
delegate and
Mr. Gogoi, see, we are not very much concerned with the approval. We are concerned with the decision-making process. How did it emanate the decision from which point did it arise that there is a requirement to change? We want to have a look at that.
There is a representation, my lord, of the minister, my lord, is there, of the local MLA, say, my lord.
That already is a pleaded case.
Yes, we have made a statement in the affidavit too. On that, my lord, basis, it started, my lord. And my lord, on public interest, it has been done. We want a better road, my lord. Especially in the low-lying areas, my lord, where there.
What about the adjoining areas?
But that's a different issue, my lord. So far as this part is concerned, there was a concern, my lord. Public, my lord, they made representations, the local MLA made representation. And my lord, it has been, my lord, proposed.
See, public
Within
interest
the
is
same
a,
amount.
public interest is a very vague term. Public interest is a very vague term.
But they will get a better road, my lord.
No, better road on the perception of whom? Public interest means the interest of the public,
Yes.
not the interest of somebody's perception. He thinks that it will be a better road.
No, my
Adjoining
lord,
areas,
there was a verification by the, my lord, district authorities of the, my lord, superintending engineer's office.
so why did
They
it,
thereafter-
no, after everything was done, see, before you are better equipped with the facts. Before you float a tender, you do all the background exercise. What kind of road would be suitable? What materials are to be used? And thereafter, you float the tender. And if in the midway, if you change, There has to be some very reasons which are extraordinary in nature.
My lord. It is, my lord, going by the, my lord, nature of job, now they are proposing, my lord, within the same, my lord, sanction amount. Not that, my lord, there will be escalation or, my lord, there will be a higher amount will be required for, my lord, executing this one, within the same amount. And they say, my lord, almost entire road will be in this manner, in the new, my lord, form. And it will have a durability.
Yes, you had said that you will have instructions whether you can do this in the same rate.
Yes.
He has no instruction, my lord.
Huh?
My lord, he has no experience, man. Well, because we have floated the new tender, there is a specific condition, that condition has not been put to challenge in the present decision. You ought to have challenged it, man. Not on the challenge. So we will see the.
Well, which condition?
Well, regarding that, my lord, new work, my lord, that they will have to, the bidders will have to have the experience of executing similar nature of law. That he has not challenged it, my lord. That clause ought to have been challenged.
That will be a double-edged sword. That condition might seem that he want to oust him.
Yes. Oh, my lord, for that development, my lord.
Mr. Chaudhary can very well argue. This has been included only to get me out.
No, my lord, it is a, my lord, it's a more updated work, my lord, it should be more durable, especially in the flood affected area or low lying area. That part, my lord, there is no doubt. In fact, it has been implemented in various parts.
I
of
think
our
they
state.
should take steps to improve Gauhati condition. This Nalbari Road 49.
Let us not
They can
let us not
protest.
talk about Guwahati in the court. We'll talk about Guwahati when the Guwahati is the subject matter. Let us talk about Nalbari now.
That public interest part is there. Otherwise, you know, they have conducted the entire exercise, the reports are before this honorable court.
Now, how did suddenly the MLA thought that this would be a better thing?
For the party hearing, my lord.
No, how did he? Is he?
Yeah.
That is the question.
He has not said that this should be implemented. He has stated, my lord, in the condition of the road in that particular area, the low lying area, and there is a large, my lord,
That
So
too
it
when
should be-
I became L1.
more upgraded one. That's the whole, my lord.
Let us hear this. We would like to.
My lord, I have one submission, my lord. If your lordship should kindly have the evidence act, section 114G. The lordship will, why lordship will draw presumption? Evidence.
No, that is okay.
Yes.
We'll
No, my lord, it's a pure and simple case of exercise of power, which is, my lord, flooded with malice, my lord. I did not speak anything further, my lord. First, they do not open my bid. They do not technically evaluate my, every stage I have to approach this court. Eventually, finally, when I became L1, now the scope of the work has been changed. Whereas the same work, which was initially tendered by the same tender, that has been allotted to the party in the adjacent area. He has done it and he has received the payment also. And two known persons are the persons who are L2 and L3.
let us hear this then.
Yes.
Oh, no, that's not here.
And my lord, there is one more aspect. There is violation of this act also, my lord.
Procurement Act.
Yes.
Hmm.
And the Honorable Supreme Court has said that whenever, my lord, there is no discernible reason as to why I was not communicated. In such a situation also, lordship has to presume arbitrary exercise of power. Section 6. Procuring this, my lord, the Assam Act of.
Mr. Chaudhary, you have to again
Yes.
recapitulate. We forgot the fact.
Yes. My lord, what had happened? An NIT was issued on 17/10/25, my lord, page 23.
$17?
10/20/25, page 23,
Yes.
by the Chief Engineer Roads.
Hmm.
Two roads were, my lord, tender in respect of two road was.
Two
called for.
packages. Two packages.
Two packages. One is, my lord, last is 48 and the other one is 49.
Hmm. You're interested in the first package?
Yes. I has emerged as L1 in the first package.
Yes.
Then, my lord, what had happened, my technical bid, they were not opening. So therefore, I approached this honorable court.
You said price bid was not opened.
No, initially technical bid also, page 24, my lord.
24.
Yes. Page 24. This is an order passed on 19/11/25. My lord, if your lordship would kindly come to page 25. Now, the writ petition was disposed of para 4 with the following direction. If your lordships would kindly come to Roman 1.
Hmm.
The site visit certificate having been issued by respondent number 3 to the petitioner on 10/11/25, it shall be deemed that petitioner has satisfied the clause. The respondent authority shall not reject the technical bit of the petitioner on the ground that the site visit certificate was not submitted. Respondent number 3 is directed to forward a copy of the said site visit certificate to the tender evaluation committee so that same can be kept on record. If in the meantime the technical evaluation period is not over, respondent authorities shall proceed with the technical evaluation period, taking into account that the petitioner had duly submitted the site visit certificate. This court has not expressed anyway, my lord, the site visit certificate they were not obliged, they were not giving, therefore I had to approach. Then, my lord, eventually page 27. Now, I am along with the other two contractor, my lord, petitioner was also adjudged as technically qualified. Page 27. Then, my lord, in respect of the other work order is issued on 11/12/25. The date is relevant, my lord. Same nature of work, same district, adjacent areas, work order issued.
Which is this page?
Another package, my lord, that's second package.
Second package.
Yes, page 28.
Work order issued.
Yes. And I think by now he has completed also. Yes. On 11/12/25.
Okay.
Then, my lord, in respect of this first package at page 29, I am adjust as L1 after opening of the financial bid.
Yes.
Then naturally, my lord, the problem cropped up because two blue-eyed contractors have been overtaken. So therefore, my lord, this new methodology that the local MLA or somebody has written something. Therefore, my lord, the department obliges by cancelling the tender. That impugn order, page number 34. This is what we have impugned in the present proceeding, my lord. Chief Engineer PWD Roads advised rebid online on behalf of the Governor of Assam for one number of package construction of road and bridges under Mala 3.0 for the year 25-26 in Nalbari district of Assam, amounting to 5948 so and so. So, my lord, and 35 is the, my lord, the new tender. 12/2/26. So in November 25, the other work order is issued. Work order in respect of the other work is issued. So at that stage, we approach this honorable court and there is a stay order operating. My lord, my first submission is, my lord, that my bid has been rejected. They ought to have informed me because there is a statutory prescription. Section 6, my lord. 20, page 23:6, yes. If your lordships would kindly have section 26, my lord.
Yes, of the Act of 70.
Subsection 3, yes. Page number 20, my lord.
Yes.
A procuring entity may, for reasons to be recorded in writing, cancel the process of procurement initiated by it. Now, subsection 3, the decision of procuring entity to
On the last date, we remember asking you whether it's come under procurement. Is the procurement? For
it
work,
includes both.
work contract as well as
Yes,
services.
works contract as well as supply.
Okay.
The decision of procuring entity to cancel the procurement and reason for such decision shall be immediately communicated to all bidders that participated in the procurement process.
Hmm.
Since your lordship is examining the decision-making process, therefore, in my humble understanding, my lord, subsection 3 of section 26 has immense significance in this case, because Supreme Court has also taken a view, my lord, in such matters, if no discernible reason is noticeable as to why it was not communicated, then it has to be construed that the exercise of power was arbitrary. Judgment তো তার নিছিল নহয় ইয়াতে আছে আছে সুপ্রিম কোর্টে জজমেন্টে আছে
Yes.
My lord, I am relying on a Supreme Court judgment on this point, my lord. 2026 SCC Online SC 24. 2026 SCC Online SC 24.
Name.
Name of the party is, my lord, Golden Food Products India versus State of Uttar Pradesh.
Yes.
Now here, my lord, I'll rely upon paragraph 5, 28 and 29. Now, basically, Supreme Court has said, my lord, at para 28, in our view, there cannot be any imprimatur of the court to such arbitrary cancellation of auction by instrumentality or agency of the state in the absence of there being any fraud, collusion, or suppression. So, my lord, I've got nothing, there's no fault on my part. Now, the reason which you have ascribed, it is a colorable one. Because you have not been able to satisfy this honorable court the manner in which this file moved. Because Lord, in a governmental agencyal function, my lord, what is of utmost relevance is how the file moves. Because that will reflect the actual decision-making process, that will reflect the application of mind to the relevant consideration. When these aspects are absent, my lord, it has to be construed to be an arbitrary exercise of power. And rules of executive business envisages a procedure, my lord, how a decision is to be taken by the minister. Eventually, the minister signs, then an administrative order follows. But until the minister signs, my lord, it is the process. That process reflects, my lord, the application of mind. Now, what was the requirement? Or it was in, my lord, pretense. Absolutely, it is a pretense, my lord. There can be no doubt. Secondly, my lord, since there is no discernible reason as to why the reason were not communicated, therefore it has to be construed as arbitrary. And my lord, finally, my lord, end of the day, now nothing has been produced before lordships to indicate what impelled the government to take the decision. So that by itself shows, my lord.
What about the affidavit?
The affidavit, they say, my lord, one local MLA has written. Local MLA is not expert on road. He can say, yes, as a local MLA, he has every right to say that good quality roads should be constructed. Then, my lord, there has to be a decision.
No, Mr. Chaudhary, even if the local MLA is an expert,
Yes.
will he have such a role that the entire decision could be changed?
No, nothing.
Which is by a department.
No, what I am saying is, my lord, supposing we presume the local MLA acts in public interest. Let us presume, my lord. He feels that this road is, my lord, infested by flood, etc., etc. Therefore, good roads should come up.
Yes.
Very well. Therefore, then it should go to the domain of
Department.
the expert.
Yes.
Then experts should say, yes, this technology has become outdated. Let us introduce this technology. Then there has to be meeting of minds. There has to be application of mind. Then only, my lord, there can be a result. So this is not the way how executive functions, my lord. So, my lord, I think time has come. They should be told that what we are examining is the decision-making process. We are not questioning the competence of the state to adopt any, my lord, method of construction of road, which they feel is good for the state. For a moment, I am not objecting to that. But the manner in which my right is sought to be, my lord, interfered with, that is something which causes anxiety to me. Therefore, my humble submission is, my lord, the process which has been adopted is far from being bona fide and arbitrary. Therefore, lordships will interfere in this matter and they should be directed to, my lord, bring the tender, earlier tender to a logical end. That is my humble submission. Lordship's kind permission, can I?
Yes,
Number
yes.
one basic matter.
Yes.
That's all.
Also, in that plans, my lord, I have placed that, my lord, communication for representation of the local ML.
In the fresh bunch.
Based on that, my lord, the entire process was initiated for the.
Which one?
May I, my lord, I forgot that.
Have you flagged it?
There in the chart index, my lord, in the first page, there is the index. It says about the representation.
Next one. Take it easy.
May I?
Oh, it will know.
No,
It will
no,
know.
not that one.
Oh, it will know. It will know.
There is the index one.
Index, yes.
Possible
What was this file, this record?
Those are the citations that.
No. No citation. Oh, citation and along some records also. Okay.
May I point out the one election number?
Just a minute. You want to have a look
Just
at this?
point out the number.
Why there are two writ petitions?
The first petition is regarding which a prayer for my lord allotting the work to the petitioner, finalize and allotting the. Lordship will find it at annexure 6. Lordship will see this annexure 6, 7, 8, 9.
Mr. Hawk, why two writ petitions?
My lord, the
948 for?
944, my lord, it is regarding challenging of the subsequent tender, my lord. It challenges the fresh tender process, my lord, 948.
Oh,
And earlier one, my lord, even on to, my lord, challenging the, my lord, only for a prayer to conclude the tender process, my lord. But that was pending, my lord. So they have issued the fresh tender, my lord.
okay. Okay. Yes, Mr. Google.
Minus 7, annexure number 7 of the plan. Possibility 7, 8, 9. 8 is the estimate revised.
7
Yes.
by the superintending engineer.
Annexure 7 is a representation.
Annexure 7 is annexure 6.
Yes, 6. 6 is the representation, 7 is the estimate.
No, 7 is superintendent of engineer, submission of estimates, correct. 6 is what is 6?
6 is the representation, my lord, to the chief engineer
By whom?
by the, my lord, the MLA, local MLA.
How do you get it? It's
My
not
lord, there
a,
is a seal stamp, my lord, down.
improvements are proposed to be taken for improvement of the roads and low lying area prone to water logging due to which likely to get damage of this project. And properly using proper technology. Get it large volume of. This has been written to whom?
The government.
It's not discernible to whom it's written. Special Commissioner and Special Secretary, perhaps.
My lord, government, my lord.
Okay, thereafter?
Thereafter, also will find the revised estimate.
Hmm.
Revised
Estimate.
Estimate in the next page.
What is the date of this? Date, is the date discernible?
Date not discernible, but whether the receipt of that, there, of that communication. But it is prior to finalization of the tender.
Dates are confusing, Mr. Goi. There's one 18/12/21 also, it cannot be 21.
6 actually, not 1.
No, it cannot be 26, also it can be, it has to be 25.
No, 1, 18, 1, 25.
No, 18/12.
It will be 25.
Okay, then estimates were 18/12
Prepared.
December. Then to estimate. These are the estimates.
Well, then annexure 9 is the approval of the government. 6/1, 2026 is the communication to the government placing on record. 6/1/26.
Yes.
Everything has been detailed in this particular letter. of
This is
the-
annexure A.
Got it. Annexure, yes. And in the second para, in fact, it has been reflected about receiving of a letter from the Honorable Minister, PAC, Housing and Urban Affairs Department, Governor Assam, for review of the design of the proposal. He has not stated, my lord, how it will be done. He has only proposed that it should be a better one, considering the nature of the, my lord, condition of the room. Earlier it was GSB, there is granular subbase. Now it has introduced CTSB, central treated subbase.
Now, city,
Now it will be CTSB, cement treated subbase. It will be more durable, more particularly in the low-lying areas. As well as flooded areas. That is the entire public interest that I was speaking about. And my lord, so far as the right of the petitioner, my lord, though the financial bid was open, my lord, no, my lord, letter of acceptance has been issued to the petitioner. So in that regard, I will place one judgment, my lord, the honorable court is already aware of that, my lord, that no indefeasible right accrues just because, my lord, the financial bid has been open. They are getting up judgments in that regard. Yeah. And thirdly, my lord, no mala fide has been alleged in the writ petition, my lord. So, my lord, various contention has been raised at the time of submission, but there is not a single averment of mala fide in the writ petition, not even, my lord, one line. Without that, my lord, averment, to, my lord, submit that, my lord, at the behest of the L2 bidder or L3 bidder or the local MLA, my lord. We have cancelled it. That will not be sustainable. Even in the submission part of the writ petition, my lord, Nothing is there on the, in the aspect of Malafide,
Yes,
not even in Milo dispute.
they agree will even us.
And they are not party in the present proceeding. L2 bidder or L3 bidder or any official Milo against whom Malafide has been addressed is not a party in the present proceeding. And Milo, the estimate Milo will remain the same. It's not that Milo, it will be a burden on the state exchequer. The estimate will remain the same. And my lord, regarding the note sheets, in the record of the chief engineer, my lord, the note sheets are there. And then annexure 9, my lord, the government has given the approval, my lord, to go ahead with the cancellation and go for fresh tender with this new clause. And that clause is not under challenge in the present process.
Annexure 9.
Yes, madam. Lords, you will see the prior portion of the writ petition.
Yeah. Yes.
Page 18 of the writ petition.
Which one?
The pair
Which one?
of the writ petition, my lord, 948, 2026, the second one.
Second one.
Yes. There, my lord, the cancellation has been successful. They have final prayed for passing of the press tender. But my lord, that clause has not been put to trial.
Yes.
One judgment I would like this one.
Yes, please.
Right of. A bidder. You will see para 15, my lord.
1-3.
Yes. Start with the heading as para 12. Mentionability of suit in absence of concluded contract.
Yes.
Para 13 stage, it is a settled law that the highest bidder has no vested right to have the auction concluded in his favor. The government or its authority would validly retain power to accept or reject the highest bid in the interest of public revenue. We are of the considered opinion that there was no right accrued and no vested right accrued in favor of the plaintiff merely because his bid amount was highest and had deposited 10% of the bid amount. As per regulation 6.2 of the so-and-so regulations, allotment letter has to be issued on acceptance of the bid by the chief administrator. And within 30 days thereof, the successful bidder has to deposit another 15% of the bid amount. In the instant case, the allotment letter has never been issued to the petitioner as per regulation 6.2 in view of non-acceptance of the bid. Thus, there was no concluded contract, regulations 6 of the so-and-so. Again, para 15, my lord. These are, my lord, various judgments that have been reiterated on this particular aspect.
15.
This court in Om Prakash Sharma's case has held that in the absence of concluded contract which takes place by issuance of allotment letter, suit could not be said to be maintainable as there was no vested right in the plaintiff without approval of the bid by the competent authority. Thus, in the wake of the aforesaid decision, in the absence of computer contract, the suit could not have been decreed for mandatory injunctions. It amounted to enforcing of contract in the absence thereof. In the light of the aforesaid discussion, it is evident that in the absence of concluded contract, that is in the absence of allotment letter, there is no allotment letter here, and acceptance of the highest bidder, the suit filed by the plaintiff was wholly misconceived, even if non-acceptance of bid was by an incompetent authority. The court had no power to accept the bid and to direct allotment letter to be issued. Merely on granting of the declaration which was sought, that rejection was illegal and arbitrary by the incompetent authority. Further relief of mandatory injunction could not have been granted on the basis of the findings reported to issue the allotment letter. Then para 20 also, the administrator had also mentioned in his letter that there was delegation of power to him. The letter from the chief administrator also indicated that the administrator was armed with the power that apart. When we signed the terms and conditions number 4 of the tender release, subject to which auction was held, provided that the presiding officer reserved the right to withdraw any property from the auction or reject any bid without assigning any reason thereof. Admittedly, the presiding officer was the administrator ACDA. Thus, as per the terms of auction also, the administrator was having the power to accept or reject the bid. The bid was more than the reserve price and there were more than 3 bidders. It's not disputed. Thus, in our opinion, the administrator had the power to reject the bid as per the delegation made to on question. So here, my lord, there is no such allegation that my lord it has been cancelled by some incompetent authority. Then, my lord, para 28. The para 25, the main heading, my lord, is my lord, legality of rejection of bid. I will rely on para 28. Starts, my lord, that point from 25.
Yes.
28, my lord, says that its court in state of UP versus Vijay Bahadur Singh has laid down that there is no obligation to accept the highest bid. The government is entitled even to change its policy from time to time according to the demands of time. It was observed as it appears to us that the High Court had clearly misdirected itself. The condition of auction made it perfectly clear that the government was under no obligation to accept the highest bid and has no right, and that no right accrued to the bidder merely because his bid happens to be the highest. Under condition 10, it was expressly provided that the acceptance of bid at the time of auction was entirely provisional and was subject to ratification by the competent authority, namely the state government. Therefore, the government had the right for good and sufficient reason. We may say not to accept the highest bid, but even to prefer a tenderer other than the highest bidder. High Court was clearly in error in holding that the government could not refuse to accept the highest bid except on the ground of inadequacy of the bid. Condition 10 does not restrict the power of the government not to accept the bid. There is no reason why the power vested in the government to refuse to accept the highest bid would be confined to inadequacy of bid only. There may be a variety of insufficient reasons apart from inadequacy of bids, which may impel the government not to accept the highest bid. In fact, to give an authentic illustration, now let's see the last precedent D, my lord. It cannot be disputed that the government has the right to change its policy from time to time according to the demands of time and situation and in the public interest. The government has the power to accept, not to accept the highest bid, and if the government has also the power to change its policy from time to time, it must follow that a change or revision of policy subsequent to the provisional acceptance of the bid, but before its final acceptance is a sound enough reason for the government refusal to accept the highest bid at any auction. So here, my lord, no letter of acceptance was issued, even though the financial bid was open. So, my lord, when an award for a contract or tender, my lord, is accepted, that has been prescribed in the Procurement Act. I would like to place that provision.
Page?
Page, what's this, my lord, page 20.
Page 20,
Yes, sir. 27, section.
27. Award of contract.
Yes, subject to the one, says subject to the provision of section 25 and subsection 2 of section 3, the procuring entity shall consider a bid as successful. These are the criteria. Lordship will see 3, section number 3. As soon as the procuring entity with the approval of the competent authority decides to accept a bid, it shall communicate that fact to all the participating bidders and also publish the decision on the state public procurement portal.
Hmm.
4, while communicating the acceptance of the bid, the procuring entity shall advise the successful bidder to complete the requirements within a specified time for furnishing any performance security in the form of bank guarantee or any other bank instrument or so and so. So this has not been, my lord, this stage has not arisen at all, my lord, in the present. Before that, my lord, it was cancelled.
So how do you, what is your reaction to 26.3?
Yes, Lordship will see, my lord, 26,
3?
section 26, subsection 1, B for a moment, my lord.
Hmm.
A procuring entity may, for reasons to be recorded in writing, cancel the process of procurement initiated by it at any time prior to acceptance of the successful bid.
Hmm.
So that right we have.
Yes.
Now 3 says the decision of procuring entity to cancel the procurement and reasons for such decision shall be immediately communicated to all bidders that participated in the procurement process.
Correct.
But even if, my lord, this was not communicated, this will not, my lord, make the entire, my lord, cancellation process a nullity. It is a procedural lapse, my lord, but my lord, when this petition was moved, my lord, immediately I placed the necessary, my lord, cancellation order. It was furnished to the petitioner.
No.
Yes, my lord, I placed it before the honorable court in the first writ petition, and the second writ petition was referred there.
You say that 26.3 is a procedural requirement. It is not mandatory.
Will be, my lord, but that will not make the entire, my lord, cancellation.
That means
process
it's not
null.
mandatory.
Yes, my lord, of course, my lord. But decision is there, my lord, because the NIT, fresh NIT has been published.
No, decision in the public domain and decision which are required to be communicated to the bidders are two different aspects. 26.3 specifically requires the decision to cancel the procurement to be immediately communicated to all the bidders.
Here it will
Now,
be in the
a
portal,
submission
my
has been made that this was not followed.
Yes, that
So-
part, my lord, apparently, since, my lord, no communication was made to the, not only to the petitioner.
Or
but
to all the
other
bidders, all the bidders.
Yes, yeah. But whether that will make the entire process of cancellation of tender and arbitration. And thirdly, my lord, that restrictive clause according to the petitioner by which, my lord, the new, my lord, this particular CTSB has been incorporated, it is not under challenge. And my lord, there is no amendment in the writ petition that by incorporating the CTSB provision in the press tender, he is, my lord, he will be excluded. Meaning there amendment that he has no experience. To exclude him, this has been incorporated in the press tender with a new ground. But admittedly, my lord, this is a new, my lord, manner of, my lord, constructing the roads, which will be, my lord, more durable in, my lord, low-lying areas, flood affected areas. And same, my lord, invite, my lord, this public interest part, my lord, will come in. They will have a better role. And, my lord, so far as the local MLA being the political representative of the area, he has every right to make such representations, and it is not politically motivated. And reasons are there, my lord, various, my lord, reports were called for. It is there in the affidavit also, I'd like to point out.
Please.
On the technical aspect. But we will see, already, my lord, in the advance, it is there. Even then, my lord, we have got it on record in the affidavit also.
In affidavit in the first case.
My lord, is the second, 948 of 2026. The running page number will be 38. Para 5 and 6, my lord, places the ground. And my lord, page 48, lordship will see technical justification pertaining to incorporation of cement.
Just a minute, just a minute, please. Which
Page
paragraph?
48, my lord.
48,
Yes, para, my lord, 5 and 6 I will rely upon, my lord. I'm not reading it, my lord.
para 5 and 6.
5 and 6. And my lord, 48,
Prohibition
lordship, has got in my
6, 7.
48 technical justification.
Now, where are your pleadings? Let us see. What pleadings?
Reading. It is, my lord, it starts at page 41, para 6.
Please read.
The deponent begs to state that the respondent department opened the financial bid wherein the petitioner was found to be L1, according to the Honorable High Court. While order details was pleased to close the petition number so filed by the petitioner before the Honorable Gauhati High Court, seeking a direction for opening and finalizing the financial bids as infructuous, observing that no further case survived for adjudication, while granting liberty to the respondent authorities to finalize the tender in accordance with law. Further, the deponent begs to submit a subsequent to the above order. While the matter was being reviewed at the departmental level, it was observed that the DPR for the said Automala 3.0 project had been prepared. In the intervening period, representation has been received from various quarters and allied departments, as well as from local public, highlighting the project road passes through low-lying and flood-prone areas. It was further brought to notice that the road caters to a large volume of heavy vehicles, including construction material carriers from nearby districts of Baska, Tamulpur, and also significant traffic originating from Bhutan, necessitating adoption of improved and durable pavement technology for long-term sustainability. Lordship will kindly see, my lord, for this particular project, these are the difficulties that they have faced. And same is not the condition in respect of the other project. There was 2 projects in the same tender.
No, traffic movements, can it be low lying? Yes, can be
Yes.
different.
No, they are trying to justify it.
No, I was trying to have the clarification from you. Low lying for it may be different from different areas. But traffic movement in packages of the same road, can it be different?
No, Lordship will see, my lord says, it was further brought to notice that the road caters to large volume of heavy vehicles, including construction material carriers from nearby district of Baksa.
Yes.
This particular area is nearby, my lord, district of Baksa. So that's why this has been said. Baksa and Tamulpur, and also significant traffic originating from Bhutan.
And the second package, that is what?
Though it's in the same district, my lord. But this particular grounds, my lord, probably, my lord, this Bhutan and all will not be covered under
The
that.
second probably would not be
That is
applicable.
clear in my lord. We are concerned with this particular project whereby it has been cancelled on this particular grounds, taking into my lord consideration of these aspects. Then lordship will see, in view of the above, the matter was deliberated and reviewed at the departmental level, and it was advised to incorporate cement treated sub-base in place of conventional layers, considering its distinct advantages such as enhanced durability, improved load bearing capacity, reduced maintenance, and minimized environmental impact. Accordingly, the concerned divisional office had prepared and submitted a revised detailed project report and revised estimate incorporating CTSB and other corrective measures, while keeping the overall project cost within the same sanction amount. And necessary administrative approvals were also accorded by the state council. Thereafter, it was cancelled. Then 48, lordship will see, my lord, the technical justification.
For it.
48.
Yes.
48, my lord, technical justification is there, my lord, from the technical authorities. 49.
What is there in 49?
There's a comparison being shown, my lord, between CTSB and granular subbase, that is GSB. GSB was the initial, my lord, project. Now, my lord, you will be CTSB. At a very initial, my lord, rows, lordship will see, my lord, structural strength high, cement stabilized. In GSB, it is moderate, water resistance very good. In other case, it is poor to moderate. Thickness is reduced. Here it is higher, my lord. My lord, why this thickness is required is, my lord, lordship will see by when we, my lord, renovate a particular road or reconstruct it, the road goes higher, my lord. Whereby the residents, my lord, and all, my lord, they face the problem, my lord, it becomes lower than the road and waterlogging is there. So this problem will be reduced.
Yes.
And my lord, expected desired life is, my lord, 15 to 20 years. In other case, it is 10 to 12 years. Maintenance cost is low. In the other case, it is higher. Suitability in flood prone area, there is excellent, my lord. Other is poor.
This new technology, where have you employed this new technology elsewhere?
Yes, it has been employed in some.
Why don't you do away with the earlier thing? Have you done away with the earlier thing?
It is still
You are
going on,
highlighting that the new technology is fantastic. Why haven't you employed elsewhere?
It is there, but not only that, for the first time, it has been introduced in Melody.
No, are you still going with the conventional granular base anywhere?
Some cases, yes, it is there.
Why?
That Melody, of course, Melody.
And why this kind of a table?
No, for this particular project.
Is this some kind of a, what do you call, a joke? You form a table, this is good, this is bad. You still continue with the bad elsewhere? Why don't you do away with the earlier?
Gradually, they are doing,
And why gradually? Is it a kind of a systematic change? You need to do it gradually.
No, Melody, why?
How many fresh tenders have you done with the old GSB?
That Melody.
Please place the records. Have the record tomorrow. Only the data. They were following the old granular base sub-base. What are the new works which are presently undergoing under the PWD?
Lots. That I can place.
Please place it. This table, you have given a very fantastic data that the new technology, same cost, everywhere you are gaining. Then why are you going by the earlier technology elsewhere? It's bad. It is higher. Residents are suffering. It is not durable. Still you are going. See, Mr. Gogoi, while you make submission, you don't think that we are not aware of what is happening.
So I will have to explain, Melody.
No, explain this, but you have to make your explanation one which is acceptable, that we have done away with the old system. It's bad.
But Melody, it will have to be somewhere, it will have to be introduced, Melody, implemented.
Have you done it?
Yeah, it is there, Melody. It's not the first.
No, have you any new tender, all new tenders, have you adopted the new procedure?
That I will have, but I will have.
That you have not done.
But Melody, here, Melody,
See, we are not questioning your expertise in adopting a new process, but that has to be a step. It has to be consistent. And if you say if this data, which you have prepared, is done by experts, then there is one process, the earlier process, which is much inferior to the new process. Yet you are going ahead with the earlier process for other works. It's not some systematic change. It's one point that from today we are adopting this new. Whether it's low-lying or not low-lying, it's a better technology.
Low-lying area, it is required, Melody.
Even if it's not low-lying, so even if it's not low-lying, then otherwise also it's a better technology. The height thickness is less, the lifespan is more, maintenance cost is less. So low-lying is not only the criteria, it may be one of the criteria. Not convincing.
But these are the grounds on basis of which they opt for.
Not convincing.
Then again 6.1 is the page 51, which was communicated to the government from the office of the sales.
5.1.
No, 5.1 is the page number. The letter is 6.1/2026.
Yes, 51.
Yes.
6.1. What is this?
This is a communication from the chief engineer.
To the department.
Yes, to the government. There they have explained, my lord. And
Please.
estimate and all, Lord, she was already paid. Basically, these are the ground, my lord. Why, my lord, they wanted to, my lord, the better road in the first project. Because there was some demand from the authorities, from the public as well as, my lord, the local level. I would like to rely upon Silpi construction also, my lord, where, my lord, it has been one para. On our Supreme Court has held that, my lord, in every case, my lord, reason is not required to be given, especially in a contract matter. It can be justified in the affidavit also before the honorable court.
Let us have it. Shilpi is, what is the citation?
This 2020, volume 16,
16, SCC.
489.
4,
489.
9.
Only one para, my lord, para 25.
How do you spell Shilpi? SH or SI?
SILPPI.
Okay,
Silpi Construction Contractors.
okay.
For example,
Paragraph?
25. Only thing, my lord, I don't have a printout.
Okay, well, just read it out, read it out. Give the printout later.
Yes, that brings us to the most contentious issue as to whether the learned single judge of the High Court was right in holding that the appellant orders were bad since they were without reason. We must remember that we are dealing with purely administrative decisions. These are in the realm of contract. While rejecting the tender of the person or authority, inviting the tenders is not required to give reason, even if it be a state within the meaning of Article 12 of the Constitution. These decisions are neither judicial nor quasi-judicial. If reasons are to be given at every stage, then the commercial activities of the state would come to a grinding halt. The state must be given sufficient leeway in this regard. Respondent 1 and 2 were entitled to give reasons in the counter to the repetition which they have done. So we have given the reasons in our affidavit. Placing reliance upon the documents is a part of the record of it. And my lord, in fact, in the other case that I placed for 2017, Honorable Court has held that, my lord,
First case.
First one, my lord, citation. It has been held by the Honorable Supreme Court that, my lord, the Honorable Court cannot direct that, my lord, it should be allotted.
The Haryana case.
Yes, it cannot, it should be allotted to the petitioner. Or to the higher bidder. Then again will be upon the authorities to decide. If it allows, my lord, we can start that from this particular project, my lord, it will be helpful, my lord. Because we will make some observation, my lord, regarding this particular job, CTSV.
Okay. That's all?
That, yes,
Anything, Mr. Hawk?
Only thing is that, my lord, here in this case, my lord, the whole thing, my lord, the concept of CTSB, my lord, they have tried to introduce, my lord, only after the evaluation of the finance bill, my lord. The finance bill was evaluated on 26/11/2025, my lord. And my lord, this new concept, my lord, they had tried to introduce, my lord, only to oust, my lord, the petitioner, my lord. And moreover, my lord, the section 6(1), my lord, of the Assam Procurement Acts, my lord.
26(1), 26(3), or 6?
6(1), my lord. Here, part of the Assam Procurement Act, it reads that the procuring entity shall not establish any requirement aimed at limiting participation of bidders. 6(1), my lord. Page 9, my lord.
6.
Now that CTSB, my lord, it was probably introduced last year only, my lord. To my knowledge, last year. And it is not possible for every contractor, my lord, to have that experience of CTSB, my lord. So somehow it would be restarted, my lord. So why not with the petitioner, my lord? Petitioner even can undertake the process of CTSB, my lord, under the supervision of the executive engineer. Their governmental authorities are there, my lord. They will help, they will guide, the petitioner will undertake. And in case, my lord, in another contractor, my lord, the contract work, my lord, that has already been completed, on the verge of completion, my lord. They did not need any CTSB there, my lord. And they are always relying
What
on
is the distance between your package and the other package?
hardly 3 or 4 kilometers.
I don't know.
My lord, they are saying low
How,
lying, my lord.
what is the stretch of your work package A?
My lord,
What is the length?
in this case, my lord.
No, you're interested in package A, correct? First package,
48, yes.
48 minutes.
40, what is the distance? It's a road, isn't it? Construction of road.
Same road, my lord.
What is the distance?
70,
13 kilometers.
13.1, page 23.
And the package 2? Package 2?
কি ভাই বুঝি না মানে 7 kilometers probably.
Probably, well, this is not a kilometer. It says from this to that.
Yes, yes.
You can calculate the kilometers from this km to this. Where is the page
Page 23
of the repetition?
of the repetition.
2, 3. Is 13.17 from channel 0.00 to 13.17.
From 0 to then, yes.
It's 13.7, 13.17.
Other is only 7 kilometers. 7.608.
Mm-hmm.
There are two aspects in the first package, 13.17 and 7 kilometers also. 0.00 to Huyarkuchi to Hadol,
One
that
and
is
two, yes, ma'am.
2, and the second package is of Akhara to Sialmari from 0. to 7.60. You're correct?
Yes.
Second is from about
Second
7.6.
The first one will be more than 20 kilometers.
Yes. Okay. We'll consider this, okay? Heard Sri K.N. Chaudhary learned in a concept for the petition assisted by Sri S. Rao. Petition it has also heard Sri B. Gogoi learned AAG representing the Public Works Department. Well, Sri Gogoi has also pursuant to the earlier orders, Sri Gogoi, the learned AAG has submitted that no separate file exists for the government, and whatever papers were available have been copies of the same have been placed before this court with an index. Hearing is concluded. Judgment is reserved.
Probably I have earlier furnished to court of judgment, madam.
If you have earlier done, no, not required now. What judgments did you?
It's already probably there, madam. Subodh.
Which one?
Subodh Kumar Singh Rathore and another Mahalakshmi, madam. Probably it is already.
And this too, today you have placed which one? Haryana. Haryana we have. Shilpi, give those only the relevant paragraphs. Subodh Rathore we have.
Yes, ma'am.
and
and Mahalakshmi.
yeah, we have,
In Subodh, my lord, that case, my lord, there, my lord, the work order was issued, thereafter it was, my lord, cancelled. So in the present case, my lord, no letter of acceptance on this. That's the difference, my lord, actually.
so about which paragraph?
My lord, paragraph, my lord, 124, my lord. 124, 125. Last, my lord, page 42 and 44.
Oh, no, Subodh, you said 94.
94 is there, my lord,
Yes.
but the conclusion don't
Okay,
in paragraph 124, my lord.
okay, that was list. We have,
Para 8 also, Lord, she will see, my lord, that's not it. There it has been stated that the work order was issued, he started the work. Para 8. Into work.
okay.
Develop placement.
Or the note can you say, can you spread? Separate totally. Okay. Yes, next.
Wait, please, Your Lordship.
Yes,
Your Lordship, here we are challenging the award dated 23/6/2015 passed by the presiding officer industrial tribunal, wherein our services was restored. But the problem is that the back wages that was not awarded. Now, the finding, Your Lordship will find at page 42, last para.
you're putting to challenge a part of the
Yes,
award by which back wages have not been given to you.
yes,
Otherwise, your services were restored.
restored.
Which page is the award?
The award starts from page 28
28.
to 28. Finding, Your Lordship will find page 42.
This is by the Industrial Tribunal,
By the-
Qatar.
Yes, yes,
Date of the award,
23/6/2015.
yes.
Now, Your Lordship may come to the last paragraph of this award,
Page
42,
40,
42,
42.
yes, last page.
How were you employed?
I was working as the Tila Babu of Maniknagar Tea State,
As?
as Tila Babu.
What is it?
He used to look after the basic loading and unloading of tea leaves in a truck, and he used to do mainly the supervisory works of the tea state. So that was
You call it Tila Babu.
Tila Babu.
Yes.
So page 42, if Your Lordship comes to
Hmm.
that. Last para, I'll read from there.
Yes, main point.
To be decided in this case whether the domestic enquiry conducted by MW2 was proper or not. The Parito's third enquiry officer in his cross-examination had contended that as enquiry officer, he issued show cause notice to the dismissed worker, but the aforesaid workman did not attend the said enquiry proceeding and sought adjournment, which was allowed. And on the second day, the concerned workman did not participate in the enquiry, but he filed one adjournment petition, which was rejected by him. An enquiry was conducted by him ex parte. So it is crystal clear from the admission of the enquiry officer in his evidence that he issued notice to the workmen to appear in the domestic enquiry to participate in the state proceeding, but the aforesaid workman did not attend the state domestic enquiry and sought time for adjournment, which was allowed by the enquiry officer. And on the next day, also the concerned workman was absent and sought time for adjournment, but enquiry officer did not allow further time, and enquiry was conducted ex parte. So enquiry officer conducted the enquiry in haste. So principles of natural justice is violated as enquiry officer submitted his report ex parte before participation of the workmen in the state domestic enquiry. So I am of the opinion the domestic enquiry was not conducted properly, as management had issued penalty order against the workmen on the basis of ex parte enquiry report. But as enquiry was not conducted properly, the order passed by the management on 30/3/2005 for termination of Sri Sabimal Maiti is set aside. Management is directed to restore the service of the workman named so and so into his service without any back wages. So this is the finding which we are challenging.
Hmm.
Now, another point.
What are your grounds of challenge?
Grounds of challenge is that there was at the time when the enquiry was initiated, at that time there was another proceeding which was pending before the conciliatory officer. So the management, without taking any due permission from the conciliatory officer under section 33(2)(1)(d) of the Industrial Dispute Act, has terminated me. So under that section, it is incumbent on the management to take prior permission. Without that,
Mr. Datta,
yes,
see, your primary challenge
Yes.
was accepted by the learned tribunal.
yes,
The termination ordered at 33/2015 was set aside,
set
was
aside.
interfered with.
Yes,
The management is not aggrieved by that.
yes,
You are back in service.
yes.
Your present grievance is
regarding back
on the aspect of back wage. So you have to confine your arguments on a
Okay.
justification to seek the back wage. Make that the first submission which you made would be in connection with your termination, which has already been taken care of.
Yes.
Back wages, how do you claim back wage?
Back wages we can claim because it was their contention that I was running a restaurant business, but they could not show any details or any evidence that I was running that I was gainfully employed. So under such circumstance, when the entire enquiry was vitiated and principles of natural justice was not followed, it was incumbent upon the management to provide me with full back wages. There is a decision also to that regard.
Decision, what decision?
That when the when the enquiry is vitiated or principles of natural justice is not followed, then the dismissed workman is entitled.
This period of 33/2015 till the award of 23/6/2015. This is the period.
The period will be, Your Lordship, from the date of suspension.
Suspension, you had got suspension allowance.
No, I was not getting suspension allowance. Therefore, I raised the issue. I raised this issue.
When were you suspended?
31/12/2003. I was suspended.
31,
12/2003.
2003,
Yes.
suspended.
Yes, so from that date, I was not getting my subsistence allowance also. And therefore, I raised this issue with my employees union. The employees union has raised the issue with the conciliatory officer. So while that proceeding was pending, the prior permission of the conciliatory officer was not taken by the this disciplinary authority before punishing me.
But that issue was already raised before the conciliation officer.
Officer, yes.
The aspect of your claim for subsistence allowance is a different aspect.
That is different aspect.
Different aspect.
Yes.
But we are more concerned from the date of termination.
Yes.
Termination was on 33/2015, correct?
33.
2005, was it 5? Sorry,
Yes.
2005.
Yes.
33/2005.
5.
And The award has been passed on 23/6/2015,
15,
10 years.
10 years,
You are seeking back wages for 10 years.
10 years.
So what are the law which governs back wage?
There
Do
is
you
one,
get back wage as a matter of right?
not as a matter of right, but the management has to show that I was gainfully employed.
No, no, no,
That is one
no, no.
aspect.
That is 17B, that's something else. Back wage is something else. Back wage is a different aspect.
Because the thing is, your lordship, I have been illegally terminated, and I was not given an opportunity also.
You were given opportunity.
One
You
day I
had
was
say,
not-
sought for adjournment. It was granted.
Yes,
Thereafter,
yes.
second adjournment was not granted.
Yes.
What is the law on back wages?
Can I
Yes.
submit one judgment?
Yes, please.
Your lordship, I have only one copy. I'll read the relevant para, and then I'll.
Yes, yes. What is the citation?
2013 10 SCC 324.
2013, 10
10
SPC.
SCC 324. Dipali Gundu Survase versus Kranti Junior.
Dipali.
Yes.
Dipali
Gundu, Gundu.
Gundu.
Yes.
Okay.
Now
Paragraph
paragraph 22.
22.
The very idea of restoring an employee to the position which he held before dismissal or removal or termination of service implies that the employee will be put in the same position in which he would have been but for the illegal action taken by the employer. The injury suffered by a person who is dismissed or removed or is otherwise terminated from service cannot easily be measured in terms of money, while the passing of an order which has the effect of severing the employer-employee relationship, the later source of income gets dried up. Not only the employee concerned, but his entire family suffers grave adversities. They are deprived of the sources of sustenance. The children are deprived of nutritious food and all opportunities of education and advancement in life. At times, the family has to borrow from the relative and other acquaintance to avoid starvation. These sufferings continue till the competent adjudicatory forum decides on the legality of the action taken by the employer. The reinstatement of an employee, which is preceded by a finding of the competent judicial, quasi-judicial body or court that the action taken by the employer is ultra vires, the relevant statutory provisions or the principles of natural justice entitles the employee to claim full back wages. If the employer wants to deny back wages to the employee or contest his entitlement to get consequential benefits, then it is for her to specifically plead and prove that during the intervening period, the employee was gainfully employed and was getting the same emoluments. The denial of back wages to an employee who has suffered due to an illegal act of the employer would amount to indirectly punishing the employee and concerned and rewarding the employer by relieving him of the obligation to pay back wages, including the emoluments. This is the copy.
What is your what is the law on full back wages? You are claiming full back wages.
Yes.
What is the first law, settled law on the aspect of grant of back wages if there is an order of restoration in service? How is it calculated? What is the percentage which is allowed by the courts? You have to make your submissions on that aspect. Any other thing?
Your Lordship, I'll.
Yes, madam. Yeah, for the management.
On behalf of the management, your lordship, where charges is partially proved, then
What is your name? B Sarkar?
yes, your lordship.
Just a minute, please. Yes.
Yes, it will, the judgment's last portion. Management side is directed to restore the service of the workman names is the mighty into a service without any back wages. Management side is directed to exempt the huge penalty charges imposed upon the workman names is suitable mighty. There is a penalty. The same has been exempted and charges have been partially proved. If partially proved, then question of back wages discretionary power of the court. That's why back wage is not granted.
Where are charges partially proved?
Yes, your lordship, kindly see page
Which?
your lordship, kindly. Your lordship, 34 page, last portion, not bad, 35 page, for last portion, second paragraph. If
Is 35.
35 page,
Yes.
WW1C, Omolindu De, one of the witness. He further stated in his cross-examination that workman had submitted explanation after receipt of the so-called notice. He further stated in his cross-examination that there are some allegations that the aforesaid workman took money from different worker of the garden, which was not paid by him later on. This is the one of the charges. And he also admitted, Sumim Martin also admitted that garden managers work is followed by him. Para number 36, 1, 2, 3, 4, 5. He further stated in his cross-examination, Subhima Maiti, that at the time of his suspension, he was working as Tila Babu, and the main duties of the Tila Babu is to discharge duties in the D section of the garden worker at the instruction of garden manager. So he has not followed the instruction of the garden manager, and for that the company has suffered huge losses. This is two charges has been proved. And if he has a unemployed, then he join the services and file petition for his back wages. But there is no burden that he has joined service and file petition for back wages, but he has not to do the same. He only filed petition. Petition is filed in the year 2016. Now it is 2026. If he is unemployed, how can he manage his family? And how can he? And in my detailed statement,
When did he rejoin his service pursuant to the award of the learned tribunal? Award of the tribunal is 23/6/2015. When did he rejoin his service?
that judgment,
Judgment.
that judgment is in favor of him, that he can join, and huge penalty has been exempted, so he may join. Definitely file petition for back wages. There is no bar. He have not do the same. He filed petition. That means he is employed, and he have not filed any evidence to prove that he is unemployed during that period. And in our written statement, page 10.
Is 10.
Page 10.
10 running page or what?
Yes, your lordship, written statement in our written statement.
Affidavit in opposition.
Yes, sorry, your lordship, sorry. Affidavit in opposition. Para 27. There's the answering deponent basic something. The petitioner is now running his own rubber plantation business, and the said business has been running from the last
Paragraph?
paragraph 27, page number 10.
Yes.
running his business last 15 years, and apart from that, present petition also has own betel nut garden,
Okay.
and therefore
এটা কি করছে এটা হিন্দি? এটা কি করছে?
petitioner is very much gainful employed, and therefore petitioner is not entitled reinstatement and as well as back wages.
What is the response to this?
Your lordship, we
What?
think
What is the response to, did he respond?
Hmm.
No rejoinder.
Your lordship, the supervisor will encroach some portions of garden and he planted the same things. This is for our information.
He encroached
Encroach
garden.
Yes, Your Lordship. This is of information given by the management.
He's so powerful.
Yes, Your Lordship, that's why he without joint file back wages from 2015, now it is 2016. And case is file 2008 onwards.
2008 onwards means?
No, he filed reference case 2008. Thereafter, judgment is given in 2015. Thereafter, he filed his petition. Now it is 2016. And as per his evidence, his age is in the year 2030, 48 years. Now it is 2016.
Second.
In the labor co, in the tribunal, evidence was adduced.
Yes, Your Lordship.
Evidence both on the aspect of fairness of the domestic inquiry as well as on merits.
Only on merits.
On merits.
On merits. And it was the evidence of one director.
So if it
of-
was on merits,
Yes.
whether the domestic inquiry is sustainable or not, how do you suffer any prejudice?
Your Lordship, first of all, that 33(2), which I was referring to earlier,
And that is with regard to their subsistence allowance.
that is in regarding to the entire inquiry. That I am saying that the inquiry has been vitiated because that particular permission was not taken as per 33(2)(b) of the Industrial Dispute Act.
So where is your pleadings in the written statement?
Uh, Page 13.
1-3.
1-3.
Yes.
Open. Here I stated categorically that I was working.
No,
on,
where is the reverment regarding?
Regarding. Issue. Your Lordship, I'd like to bring to your Lordship's notice paragraph 42,
42.
42 regarding the enquiry which was pending before the ALC, conciliating officer. That the Assistant Labor Commissioner issued a letter by office memo number so and so dated 9/9.
Now, Mr. Datta, once the award has taken care of the situation, your termination from service has been interfered with. Now, we are not, that is not the subject matter of challenge by, in a proceeding initiated by the management. They have accepted it. Now, we are adjudicating your prayer for back wages. Towards that, what are your submissions?
Your Lordship, the submission will be only that as they could not show that I was gainfully employed and I was wrongly terminated, I was not given an opportunity also. Therefore, I'm entitled to full back wages.
Let us see the discussion of the learned tribunal on the merits.
Lordship, the primary, that main finding your Lordship has already read at last para.
No, that is
And,
the.
regarding the rest of the discussion, your Lordship will find only the excerpts of the evidence.
Where is it?
That evidence your Lordship will find from page number 33 onwards. There 34. 34 towards the end in support of this case. I'll read from that. Hmm. 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 Could have very everything about the control. Hmm. Hmm. Connected. 1B.
It appears that the management did not take steps to prove the case on merits before the tribunal. You had adduced evidence only in the context of your domestic inquiry. See, there are two stages in a tribunal. First, the fairness of a domestic inquiry. If you fail, then you can adduce evidence on merits before the tribunal. That part you have not ventured into. You're only trying to justify the domestic inquiry in which you had passed an order of discharge or termination from service. Now that the learned tribunal has interfered into by saying that no adequate opportunity was given. So domestic inquiry fairness has been decided in his favor. Then the next recourse which was available to you was to give evidence on merits, which you have not done. And rightly, the tribunal has interfered with the order of termination. Now, that order you have not put to challenge. That has attained finality. Now, on the aspect of back wages, there are many case laws which has laid down the parameters how you can proceed. There can be a full back wage, there can be 50%, there can be 25%, depending on what.
That is given. If any charge is not proved, then full backward is given. Otherwise, this is the discretion power of the court to
Yes.
decide it.
Where is the decision?
Yeah or not?
Now, where are the materials from which we can come to a conclusion that the charges were partially proved?
Partial proof very clear at the time of Tilabov. We follow the instruction of guardian manager.
No, he did not participate in the domestic inquiry.
He that he said that there is a pending of title suit, so he goes to the title suit, not come before this domestic inquiry. That's why the
Where are the proceedings of the domestic inquiry?
this is the logic and
No, where are the proceedings? There has to be a proceeding where you had conducted an inquiry, maybe ex parte. You had adduced evidence through 5 numbers of witnesses. Their statements might have been recorded. Then the inquiry officer has come to a finding of proof of the charges. Those are not before us. So how do you say? How do you contend? How do you support your?
That's why this judgment is given. And if this judgment, president has decided that he is partially proved and he is instead in the subject and penalty has been.
Where is the discussion? Where is the finding that it is partially proved?
See the
Page?
in his procedure, page 41, charges, in subordinate disobedience of his superior order.
Where
Number one.
page?
Page 41,
Yes.
charges, number one.
These are the charges.
Charges.
Then?
And stated that I have to follow the instruction of guardian manager.
Yes.
Now, at the time of guardian manager, he's a syllabus. So he has not followed.
So where is there is no admission that he has not followed.
Means prosecution yesterday.
Where? Let us see again. There is no admission, madam. We have read this.
Number 36.
Please go slow.
Page 6.
Yes.
36.
Yes.
Criminal might be into evidence or evidence has supported the case of the landed council and group of the management.
Cross-examined. Okay, then
If under certificate for a that this evidence on
drafted. Okay, then
prosecutor that never submitted any paper to show that.
is member of.
IT.
He had stated in his prosecution that at the time of the suspension, he was working as
Sheila Bobo.
and the main duties of the syllabus is to discharge duties to the section of the garden worker
Yes.
at the instruction of garden manager.
Yes. Where is the admission that he has not followed the instruction?
That's why the company has used lost.
No. Where is the admission? He said that this is his duty. He says that it is his duty to discharge duties as in the T section. Is this an admission that he has not discharged?
Yes, your lordship, there is another page 35,
Yes.
35, last plus first key. This is the witness for future. If participated in this process, there are some allegations.
Yes.
The aforesaid workmen
Took money.
took money.
Yes. Is there
All
an
the people have agreed.
Madam Sarkar? He said that there are certain allegations against the workmen. Does it amount to an admission?
But
It is not an admission. Has he said that the allegations are correct? Yes. He said there are allegations against the workmen. It is admitting to the aspect of allegation being leveled against the workmen. Does not accept that the allegations are correct.
But they have admitted that need not be true.
Where is the admission? Please,
This exhibition, they
where?
have admitted that they have taken money from the.
please show us the part.
From return.
Please
This is
show us.
not the allegation.
Please show us that part that he has taken money. He has admitted.
The allegation is that he has taken money and not the return.
Where is the admission?
Admission, there is no, but garden.
Allegation, you can make any allegation
But
that he is a thief, he has murdered people. He may say, yes, there are allegations. Does it amount to an admission of the allegation? If you are saying that there are admission, then he is to say, yes, these are correct.
but he has not given any evidence to show that he is unemployed. Nothing. We know this. He has not, the burden is to prove the case plenty. That's why we have not given any evidence to prove that he is unemployed.
See, before a tribunal, it's not a question of a civil court being a plaintiff and a respondent.
Goes to the.
What burden? In a tribunal,
Yes,
it's a
yes.
reference. It needs to be answered by a tribunal. Both the parties, they file written statement. It is not neither called a plaint. It's both the written statement, written versions of both the parties.
But she's only stated that I am unemployed, but I can maintain from 2008 to 2026. It is possible.
That assumption will not quite come.
This is.
Somebody has survived for 10 years without food.
And he has encroached the land and yes.
Where is your allegation that he has encroached land?
But they have not denied.
No.
this
Where is your allegation?
allegation.
Where have you put it?
In my written statement.
Let us see. Where?
Is it
Page
27? Page
10.
27.
Page 10.
In our evidence opposition, page 10, para 27. That the answering deponent being to submit the.
Just a minute, please. Running rubber plantation.
Yes, they don't deny the same. If they deny, then it is the question of pay. No.
Your
They were
Lordship,
denied.
that
They
has been
did-
filed
they
after
have-
filing this writ petition.
Yes.
This affidavit has been filed after this period when I was reinstated. So I'm claiming only up to 2016. From my suspension from 2005 till 2006.
Suspension till your termination 2005, that part we cannot touch upon because you say that there is a conciliation pending.
Yes, yes. there
That
was-
will take its own turn.
Okay.
But what about, let us see paragraph 10 again. That with regard to statements started,
Mm.
53.
Mm.
Paragraph 27, madam. 27. That the answering deponent states begs to submit a petitioner is now running his own rubber plantation business. And the said business has been running for the last 15 years. Mr. Datta, last 15 years.
Last 15 years. But in the
And
evidence,
apart from the present petitioner has his own betel nut garden. And therefore petitioner is very much gainfully employed. And therefore petitioner is not entitled reinstatement as well as back wages.
Your Lordship, I'll read for once the evidence of the director of Sylhet Tea Industry. What he has stated in the reference case.
Hmm.
See, this is, he
Will
cannot
be-
prove.
Cannot prove, this is a part of the evidence, Your Lordship,
This is the restaurant.
in the
This is not a
reference
place.
case.
He said that but cannot prove. How can prove whereas
They are
goes to
saying
see there is a
something else.
restaurant and there is a public sitting on the restaurant? It is impossible on the part of the management director.
No,
So
I'll read.
this cannot be proved, Your Lordship.
What cannot be proved? If there's a fact,
He is stated in the main town. Garden is in the Maniknagar tea estate. This is
you cannot go to
garden.
the town.
No, but how?
You
can
could have
prove
gone
this is
there,
the
had some food there in his restaurant.
He said running the restaurant, it is impossible. That's why it is not proved. Okay.
They could have annexed the bills also.
You don't provide bills
But
to avoid GST.
may I read for once this evidence, Your Lordship, what they have stated in the reference case. We have received conciliation notice from the conciliating officer, but we did not attend the conciliation proceeding. We have not filed any supporting vouchers to the accounted loss caused to the gardens. Regarding the thing which they were telling that we have encroached in the garden, that is also not true. Supporting vouchers to the accounted loss caused to the garden by the connected workmen by unauthorizedly occupying the garden quarter. Then I myself saw the restaurant belong to the connected workmen. I have not filed any document to show that the said restaurant belongs to him. This part has been admitted in the evidence of MW1. Sri Ranveer Roy is the director of Sylhet Tea State.
Both Mr. Datta and Madam Sarkar, we were expecting some assistance on the on the issue which is before us.
Your Lordship,
You have not been able to assist.
some time will be granted.
Why should you give time? See, there are two aspects. First, to seek back wage, there would be principle of no work, no pay. Admittedly, you have not worked. So your contention would be, I was forced not to work.
Yes.
How do you make that contention? You have to make out a case that no procedure which are prescribed in law were followed and you were straight away terminated from service. That can be one ground, that your termination is grossly illegal. You are forced not to discharge your duties. That may be a point to consider back wages. Now, the second point, whether they had adopted some procedure which has been interfered by the tribunal on some grounds, but some procedure was adopted, which in this case is in the form of a domestic inquiry. It was an ex parte one, no problem. But procedure was there. It was not that you have been thrown out of the service. So under those contexts, what has the Honorable Supreme Court said? what is the percentage of back wage? Can it be given in view of the doctrine of no work, no pay? Whether you are forced,
Decision
whether
which
any
has-
procedure, no procedure at all were followed.
That decision which I submitted, that 2013, there the court has said that when principles of natural justice are not followed, then also back.
The principle of natural justice is what? Giving an opportunity. You are given opportunity, number of opportunities.
Mandate.
You sought time. Time was not granted. We cannot go, whether we go into the justification of that, that's a different matter.
But only 2 days. A notice was sent.
Whether that's a reasonable action or not, that's a different matter. But it will not amount to not giving an opportunity. You are given an opportunity. No notice given, we proceed, that's not opportunity. You are given an opportunity, you have a problem. We don't accept your problem. That may be an unreasonable decision. That is on a different premise. 14 will come, may come, but not the principles of natural justice. So there are decisions where percentage have been prescribed that in a given case 25% or 50%, 100% backwards as on today is totally gone. And it's not a case that no procedure of any manner was followed. It was followed.
One procedural violation is there directly, that section 33.
That is pertaining to a subsistence allowance. For that, we'll leave it open.
No, if that permission was not taken, the entire inquiry which has been conducted, thereby terminating me, that has also been vitiated.
No, that for that termination order has been interfered with by the learned tribunal. That is not put to challenge by the management.
Yes.
That is at finality. There are case laws. Itu mo yata din boleh habis kan tu yo. Did you do it? Huh? Huh? Oh. Yes. That's all, madam.
Another decision, Your Lordship, regarding this 33, which I was saying, that has said, para 13, the proviso to section 33(2)(b), as can be seen from its very unambiguous and clear language, is mandatory. This part from the object of section 33, in the context of proviso to 33(2)(b), it is obvious that the conditions contained in the said proviso are to be essentially complied with. Further, any employer who contravenes the provision of section 33 invites punishment under section 33(1) with imprisonment for a term which may extend to 6 months, or with fine which may extend to 1,000, or with both. This penal provision is again a pointer of the mandatory nature of the proviso to comply with conditions stated therein. To put it another way, the said conditions being mandatory are to be satisfied if an order of discharge, dismissal passed under 33(2)(b) is to be operative. If an employer desires to take benefit of the said provision for passing an order of discharge or dismissal of an employee, he has also to take the burden of discharging the statutory obligation placed on him in the said proviso. Taking a contrary view that an order of discharge or dismissal passed by an employer in contravention of mandatory conditions contained in the proviso.
Mr. Dutta, those would have been relevant if the
Tribunal
order of termination was not interfered with. We are only on a very limited scope. As your prayer would read that you want back wages. Okay. The instant petition instituted under Article 226 of the Constitution of India is for the following relief. Page 10. Para. As per the facts projected, the petitioner was appointed in a clerical post within bracket Tila Babu in the Manik Nagar Tea Estate in the district of Kachar in the year 1994. Full stop. He claims to be a permanent worker of the said tea estate. Full stop. While discharging his duties, comma, a show cause notice was issued on 31/10/2003 on certain allegations, which was replied to by the petitioner on 4/11/2003. Full stop. The management, by letter dated 5/6/2004, had directed the petitioner to appear in a domestic inquiry, which was scheduled on 26/20/2004. Full stop. However, the petitioner had sought adjournment on 2 occasions. Full stop. The request for the adjournment, however, was rejected, and an ex parte disciplinary inquiry was held, culminating in an order of dismissal from service, wide order dated 30/3/2005. Full stop. The matter was raised on behalf of the petitioner by the union to the appropriate government, which had made a reference to the learned industrial tribunal, Kachar, in the following manner. Reference to quote, reference to portfolio. Para. The reference was contested by the parties. Full stop. The learned tribunal, after perusal of the materials on record and the proceeding of the domestic inquiry, had come to a finding that no adequate opportunity was granted to the petitioner to defend himself, and therefore the order of dismissal dated 30/3/2005 was interfered into, directing reinstatement of the petitioner. Full stop. However, no direction for payment of backwage was passed. Full stop. Aggrieved by the second part connected with the backwages, the instant writ petition has been filed, which is indicated in the relief extracted above. Para. I have heard three. Has your full name?
Siddhant Datta.
Siddhant Datta, learned counsel for the petitioner. Full stop. I have also heard Ms. B. Sarkar, learned counsel for the management. Para. Sri Datta, the learned counsel for the petitioner, has submitted that there is no dispute that the domestic inquiry was held ex parte, and without considering the prayer for adjournment, the petition was rejected, and therefore there was gross violation of the principles of natural justice. Full stop. He has also submitted that on 31/12/2003, the petitioner was suspended, and on the issue of non-payment of adequate subsistence allowance, the matter was raised with the employees union, which had accordingly approached the conciliation officer. Full stop. He has submitted that when such conciliation was pending, the the impugned order of termination of dismissal, termination of service could not have been issued. Full stop. He has also submitted that since the learned tribunal had interfered with the order of termination, comma, the order of payment of back wages should have been forthcoming, which was not done, full stop. He has submitted that due to the illegal action of the management, comma, he was not able to discharge his duties, and therefore non-payment of back wages would not be justified. Para. Per contra, comma, Ms. Sarkar, the learned counsel for the management, has submitted that the petitioner, as workman, was given sufficient opportunity to participate in the domestic inquiry, which he, on his own volition, had failed, had chosen not to do, full stop. She has emphasized that the petitioner was indulging in dilatory tactic to prolong the matter, and as a matter of fact, comma, the first adjournment was granted, and only on the second occasion the prayer for adjournment was rejected and the domestic inquiry was held, in which as many as 5 numbers of witnesses were examined. Five or 4? 5 numbers of witnesses were examined. Full stop. She has submitted that the finding arrived at by the management to terminate the petitioner from his services were done in accordance with law. Four, accordance with law. Full stop. She has also submitted that so far as the direction for the order of interfering with the termination is concerned of the learned tribunal, comma, the management has not put the same to any further challenge, full stop. She, however, contends that a claim for back wages cannot be a matter of right, more so when the order of termination was preceded by a procedure established by law. Full stop. Para. The learned counsel for the management, by drawing the attention of this court to the affidavit in opposition filed on 27/5/2022, has submitted that specific statements have been made that the petitioner was gainfully employed by running a rubber plantation, full stop. In this connection, comma, the pleadings made in paragraph 27 are pressed into service, which read as follows. Page 53, para 27, para. The learned counsel for the management accordingly submits that the writ petition is without any merits and liable to be dismissed. Para. The rival contention, sir. Para. আৰু এটা হেৰি লিখিবা হা তাৰ আগত ডক্টৰ লিখিবা. In support of his submission, the Sri Dr. the learned counsel has relied upon the decision of the Honorable Supreme Court in the case of Deepali so-and-so, reported in so-and-so, and the observations made in paragraph 22 are pressed into service, which are as follows. 22 quote koriye. 22 had said, Mr. Dr. 22, paragraph 22.
Yes, 22.
Rival submissions, per. As indicated above, comma, the present writ petition has been filed only with a claim for payment of full back wages to the petitioner. Full stop. A claim for back wages have to be examined in the context of the nature of the order by which the employee was kept out of service. Full stop. In other words, comma, it has to be examined as to whether any procedure was followed before such action was taken. Full stop. In a given case, comma, where no procedure worth its name were adopted and an employee workman is terminated from service, comma, the matter has to be viewed from a different angle. Full stop. However, in the instant case, comma, it is found that a domestic inquiry was indeed held pursuant to a notice, a show cause notice, which was replied to by the petitioner. Full stop. When the reply of the petitioner was found to be unsatisfactory, comma, notice of domestic inquiry was issued in which the petitioner, as workman, had prayed for adjournment. Full stop. It is seen that only in the second instance of making such adjournment that the same was rejected and the domestic inquiry was had gone ahead, in which, comma, as noted above, 4 numbers of witnesses were examined. Full stop. The learned tribunal had found fault with the award, with the decision of the management, and had interfered with the order of termination, mainly on the ground of violation of the principles of natural justice. Full stop. Though this court is of the prima facie opinion that the petitioner was in fact given notice of such inquiry, and under those contexts, whether the aspect of violation of principles of natural justice would come or not, comma, since the aspect of the award directing reinstatement is not the subject matter of challenge, comma, this court would not go further into that issue. Full stop. Para. As observed above, comma, the order of termination was preceded by a show cause notice, followed by a reply and a domestic inquiry. Full stop. In the domestic inquiry, however, the petitioner could not, did not participate. Full stop. It therefore cannot be said that the termination from service was done without following any procedure prescribed in law. Full stop. This court has also noted that in respect of the specific pleadings that the petitioner has gainfully employed, as stated in the affidavit in opposition filed on 27/5/2022, comma, there is no rejoinder affidavit filed by the petitioner. Full stop. Therefore, comma, this court cannot come to a conclusion that the petitioner was not gainfully employed in the intervening period. Full stop. Under those facts and circumstances, comma, this court is of the opinion that the petitioner has not been able to make out a case for grant of back wages for the period in question. Full stop. The petition accordingly stands dismissed. Full stop. So far as the claim for adequate subsistence allowance is concerned, comma, since the same was said to be before the conciliation officer.
Yes.
Conciliation officer, comma, rejection of the writ petition shall not cause any prejudice to the adjudication of the said claim, which has to be done in accordance with law.
Question.
Yes, Mr. Das.
My lord,
In this writ petition, we challenging the order dated, my lord, 9/5/2024, my lord, that imping order dated, my lord. That is annexed 3.
What is it about?
That is, my lord, the petitioner was allotted a plot of land in the market area on 19/4, that is annexed on 19/4/2024, my lord, for construction of shop for temporary basis.
On temporary basis.
On temporary basis.
Thereafter,
Thereafter, my lord, there is some, as per their intimation, my lord, there is some public complaint against the petitioner. They stayed
where
on
is this place?
my lord,
Where is this place?
there Cholantopara Daily Bazaar,
Where? Which district?
Bongaigaon, my lord, Boitamari, Bongaigaon, my lord. And that order was
This allotment was done by whom?
done by respondent number 4.
Who's for?
Respondent number 4, executive officer of Boitamari Anchali Gaon Panchayat,
Bhutamari.
Boitamari, district Bongaigaon, my lord.
Anchalik Panchayat.
Anchalik Panchayat, my lord.
There was a public complaint against your shop.
Not against my shop. There is a public complaint as per their allegation. There some people came and having some problem that the construction of shop will create some my lord, kindly say that complaint, my lord.
Thereafter, what happened?
Thereafter, my lord, they temporarily stayed the order. My lord, after the, without informing us, without giving an opportunity to hearing us, they stay the order.
Okay.
Thereafter, on 15/5/2024, we filed a representation before the respondent number 4 to withdraw his stay order, my lord.
When did you file representation?
That is 15/5/2024, my lord.
The page?
Page 24, my lord, of my writ petition.
20?
24.
Okay. Representation to withdraw to revoke
Yes.
the stay order.
Yes, my lord. But nothing was done. Accordingly, I filed challenging this order before this honorable court. Honorable court on 31/5/2024, status quo order was given in present of their counsel also, my lord.
Status quo.
Status quo order, my lord. Both the parties are, my lord. And thereafter, my lord, in the meantime, my lord, some people came and digging a well in the construction area in my shop, my lord. And when I informed this court is directed us to bring the record in the writ petition as in filing additional affidavit.
Yes.
And I filed an additional affidavit. And bring in the record or enter things, how they are entered and how
Who's digging a well?
as per some person came, Ananta Malo, Tiken Kalita, Diganto Das.
No, we are not concerned with the names. Who are these persons? They are authorized by the panchayat.
No, my lord. But this is a connivance with the respondent number 4. And they are digging well forcefully, even they know there is a status quo order, my lord.
So what is your claim here in this petition?
My claim is, my lord, that that's 2 years temporary construction. I have completed 95 of the construction of my room. So my claim is that at least temporary order may be continued till to 2 years. Thereafter, my lord, that is the asset for the market area. Then
The initial allotment of 19/4/2024 was for 2 years.
only for 2 years, temporary basis, my lord. And
That is your case.
that is my case. And thereafter, my lord, after strict instruction of this court, they filed an affidavit in opposition. On 16/3/2025, 26, my lord. In that case, There is so many contradiction in their own paragraphs. My lord, kindly see that the paragraph number 11, my lord.
Hmm.
May I read, my lord? That
Page?
is at page 47. Affidavit in opposition, my lord. Paragraph 11. That in regards to the respondent, paragraph 9, the writ petition, the dependent vexed state that the petitioner submitted a representation on 15/5/24, which are annexure 4 of the writ petition, my lord, before the executive officer Boitamari Anchalik Punjab Boita Assam for withdrawing the impugned order dated 9/5, and the same is under consideration as per administrative procedure, my lord. And then come to the page 48, paragraph 16, my lord. That the deponent vexed that the petition was submitted by the president of the Chalanta Market, Chalantapura Jogi Police Station District,
48, paragraph 16.
paragraph 16.
Hmm.
13.5, where it mentioned that the petitioner doing his construction of shop demolished the public toilet well, which were constructed of public use, and accordingly the office of the respondent number 5, order bearing so and so, dated the petition informed to do the needful so that public toilets as well as demolished by the petitioner can be again used by the public, and since the petitioner filed to comply with the Office 9520, the temporary allotment order was 19/4/20 stood cancelled, rejected with the immediate effect, my lord. They are cancelled, rejected.
In
my
the
lord,
area,
without
there was a
information.
public toilet.
No, my lord. That is, I have coming on. There was a public toilet, and that toilet was constructed by the under the chairmanship of the petitioner. That is my reply. In reply, paragraph annexure 1, paragraph 70, my lord.
Reply affidavit.
Yes, reply affidavit. There is a notification, my lord.
So what is your ultimate prayer, Mr. Das?
My prayer is that the allotment order was the stay of allotment order was cancelled, and
You were against this 9/5.
9/5.
9/5 is which page?
9/5 in my lord, page number 21, my lord. That is
But
petition.
did any right accrue upon you by 19/4/24?
19/4/24 is the allotment order.
And did any right accrue upon you?
Yes.
19/4 immediately. Now let us see again page 21.
Page 21, the letter regarding state the construction of new shop premise in the toilet Charanpur Bazaar. That is the stay order, my lord.
Let us see. With subject was has
Okay,
informed
but-
there have been allotted temporary sensor names of road and old toilet. For demand of public and local to the temporary allotment. State protest also informed so that to use the old toilet and water from the well to serve. See, there appears to be some public interest involved.
Yes, my lord. That is how, my lord, that kindly see that notification, my lord. Notification was issued on 16 November 2023.
Page?
Page 70 in my reply, my lord. The implementation of scheme running water system with content of latrine and urinal and Chalantavara Bazar under 4 of JPC under 15 Finance Commission Grant Tide Fund in the year 2021.
Where are you reading? Page?
Page 70 in my reply.
70.
70. 23.
Paragraph?
My first notification, my lord, that is
Page
page 70. 70.
71 it would be.
Oh,
Is
71.
it 611?
611, my lord.
It's 71.
This is a notification for construction of running water system with latrine and union Chalanta Bazar.
Yes.
Under the chairmanship of the petitioner, my lord.
Hmm.
So the latrine and the running water system already is constructed in the market area in 2023, my lord. And that is approved on that is proved in 6/4/2020 letter by the lessee. That is 72 maybe, my lord. There is information to the block development officer by the lessee, my lord. Next page. It means, my lord, construction is already been done. There is a latrine, there is a, but the thing is that the old toilet that was create a hazardous situation for the market area as well as the shopkeepers. Then only they are allotted this land to us. Now kindly see.
But this was constructed on 6/4/26.
No, 6/4/26 is the information given by the lessee to the respondent number 24. Respondent number 4, my lord. Boitamari Block Development Officer. He is newly appointment, maybe, my lord. And 74 onwards, these are the photographs, my lord. And the most vital thing is this, my lord. That Kishore Kolita, who is filed the reply, if it been in opposition, kindly see in my reply, my lord, there is a forged one. How, my lord?
Okay, we'll come back at 2 o'clock. Mr. Doctor, your stand, we'll have to hear. Yes, anything, Mr. Sharma?
My lord, item number 8 and 9, my lord. My lord, this message may be taken up next Tuesday or Thursday, my lord.
Next Tuesday, we have already filled. Thursday, it may be possible.
23rd. Thursday, 23rd.
On a joint request, Mr. Das?
Yes, sir.
Not joint request, huh? Matter the adjourned to be listed on 23rd.
Thursday.
Okay.
Obliged.
Can it be on 28th or 38th, or 30?
Well, that's a motion day, so it is.
30 is Thursday. 30.
My-
30.
Mani, kindly look out their evidence, affidavit in reply, madam. Affidavit in reply, it is signed by one Kishore Kolita. As per my information, that affidavit in reply was filed forgedly by Kishore Kolita. That is, I have stated in my reply.
In opposition.
In opposition. Filed by the respondent number 4 is a forged one, my lord.
Affidavit is forged one.
Forged one, my lord. I have filed my reply. Kindly see the paragraph 5, my lord.
Who is he? He is the ICBDO.
ICBDO, my lord. My lord, this person is transferred before the filing of the this affidavit in reply prior to 1 month before and handed over his charge on 13/3/2026 as a BDO of Gojamari Anchalik Panchayat. Thereafter, on 16/3, he filed this petition, my lord. And accordingly, my lord, last date I have raised this objection before the court also. Court also directed them to keep the record in hand. But I don't know whether, because it needs to a record, because record will says exact what will happen, what was happening. And that affidavit in reply is filed beyond the 2 years back after filing this writ petition. After filing this writ petition, after 2 years when this affidavit is filed, my lord, affidavit in opposition is filed. And that too is a forged one.
Forged one.
Yes, my lord, that is, he is not at all a video when the affidavit was filed. His discharge is post as a video on 13/3/2006, my lord. And he-
26,
30,
26,
26.
not
And he
26.
signed this affidavit on 16/6/30,
Yes,
2006.
what is this, Mr. Doctor?
That is another thing. That is a pure technical is raising well. But my original documents are with me. By which, my lord, he was, my lord, the notice was served on him, my lord, the complaints were received, my lord. Before that, my lord, I.
No, that is a
No,
reply.
if you can, if you,
No, my lord, before staying this order or cancellation, no notice was served upon me. Till day, after filing of this affidavit in opposition, we came to know that our application was rejected. Stay order was absolute and the allotment was rejected. Without giving a single opportunity to hear us or giving a notice. And if how the notice is served upon us, that is also not known by me. If there any record available, that I have not to say. But this is a clear cut of violation of natural justice and administrative fair play. That was good.
no, that was a temporary measure,
Yes,
for it was not a cancellation.
yes, that
Let it be
is
an
a state.
cancellation, giving you an opportunity, the aspect of giving you an opportunity may arise. It is only a matter of stay of the initial allotment of 19/4/2024.
Yes, but that is, we are also not known. Or-
That is a temporary measure. Now we want
temporary
to.
measure, but
Yes.
that is already cancelled on 13/1/2000, 13/5, my lord, as per their reply, my lord.
13?
Hence, 31/5/2024, my lord.
Where do you get?
Their reply, my lord, page 57, my lord. Affidavit in opposition. And the grounds of the cancellation is kindly see. There is serious difficulties of absence of the toilet and,
But this 31/5 is not put to challenge.
but we do not have the, having any knowledge about this. We have came to know from this thing after filing of this petition, my lord. How can we challenge it that time, my lord?
And the order of status quo was passed when?
Our 30 was same day, my lord.
Huh?
Same day, 31/5/24. And that day they are cancelled. Because their counsel is present before during the hearing of the motion. That is, my lord, this is a clear cut of laws violation.
Now, when was it moved?
31/5/2025.
He was not with instruction. How do you expect a council to be with instruction on the motion day?
My lord,
It was on the motion day.
31/5 is a
Motion day,
yes.
how do you expect him to have the instructions?
That is all right, my lord.
31/5, you cannot
But
ask any person
but
upon
they
the
should have
council
given, they
that
should,
he is not aware what is happened on
at the,
31/4.
my lord, kindly see, my lord, when the 35/2024, the complaint was raised by some persons. Whether they are the local people, they are the shopkeepers, and 31, they are cancelled, my lord. Page 55 of their reply, my lord.
But aren't you required to amend the writ petition?
My lord, I think,
If you are serious about your challenge,
yes, my lord,
at least this writ
Please.
petition requires to be
request
amended.
to amendment, my lord.
First, let us see when was the status quo order passed.
31/5.
And on the same date, you say that they have passed the cancellation order.
Cancellation, and that to know by after filing of this reply. On that day, we are not known. Neither they have informed us, not given an opportunity to hear. And after 2 years, that too, this opposition is filed is forgery, my lord. That person, he is having no locus standi to file this file because he is not in a charge.
31.5, let us see the records, 31.5.
And the complaint was 35, my lord. After 1 day, my lord. Next day, they are cancelled.
That is not correct.
That is their annexure. They have annexure 55. I am not saying there's
Then
no document.
another complaint is there. The complaint is there before them. They will be precedent on.
Whether they are public or not, we are not knowing.
This 31.5, Mr. Doctor, you had passed, did you give him any opportunity?
No, my
My lord, I lordship may kindly sometime.
Yes.
Before that, my lord, lordship may kindly have the affidavit and reply they have filed. Page 71.
Hmm.
This is one notification, my lord. For my lord, development of some scheme running water system with construction of latrine and urine at so and so bazaar, my lord. And serial number 1, he is the president, the
Yes.
chairman of that
Yes.
scheme, my construction scheme. And he is the petitioner here.
Yes.
Now, lordship may kindly have my lord, page 14 of the report.
Yes.
After construction, my lord, he was the chairman. He immediately filed application for allotment without any tender or something like that. Lordship may kindly have the page 14 and answer 1.
Hmm.
As per your application dated 19/4/2024, you are hereby allotment of land for shop at Chairman Daily Bazaar area measuring the length of 24 feet and breadth 20 feet, boundary by market, shed in north boundary wall of government hospital in the south, so and so, my lord. And period from 19/4/24 to 36/26, which has already overmade. So his basis of this case is this page 14. That period is already overmade. And it was, my lord, also mentioned that without any notice, any assigning any reason, that can be cancelled because it's a temporary one only. And nothing, no rent, something like nothing has been mentioned that how he will pay to the Anchalik Panchayat or something like that, man. And thereafter, my lord, in that records, my lord, some public complaints are there, my lord. He was unauthorizedly constructing, my lord, over the, my lord, toilet area and the well area, my lord, where the other publics were using. Thereafter, immediately, my lord, one temporary order was passed, my lord, staying the construction, my lord. And after that, my lord, the impugn order was passed. Final order, my lord, that cancelling the earlier order. His initial order was invalid, my lord. That is why, my lord, now, my lord, he cannot claim that natural justice has been violated because before passing the final order, my lord, temporarily that was suspended, my lord, on public complaints, my lord. And that period was also over. So now this case has become infructuous, my lord.
What is page 15? Page 15, what is it?
This is the public requisition. Mother resolution
Regarding what?
regarding the construction of shop between the petitioner and the Bazaar committee. Or
What is the resolution?
their resolution, they are amicably resolved that the petitioner will construct two rooms, one for sitting area of the Bazaar committee and another is for the petitioner for
Personally.
not personal, for the business purpose of the allotted area land. And if lordship is kindly see page 55, my lord, sorry, page 32 of my additional affidavit. 32 annexure 5.
Where is the document that he was made the secretary?
That's page 71. It's chairman, my lord.
Under his chairmanship, the construction was done, my lord.
Being the chairman of that scheme, my lord, he cannot claim over the right over that money.
No, my lord, he is the chairman, under his chairmanship, the construction was done, my lord.
The public money, my lord.
And he used that public money for the construction.
Just a
of
minute,
the
just a
building.
minute, Chairman. Joint. And where is the stay order? Where is the impugned order of stay which you had enclosed, which you had challenged?
Impugned order, my lord, stay order is page
21.
21, my lord.
No, not 21, 21.
21, 9/5/2024.
But this stay order clearly mentions that the land allotted to you was in the same area of the old toilet and the well.
Yes, my lord. Kindly see, my lord, page 32 of my additional
Then
affidavit.
how do you
my lord.
take advantage of your position?
No, that already new construction have been constructed the
Now, how do you take
toilet.
advantage of your position as the chairman of the committee scheme?
No, we are not acquired the possession. We are applied.
How do you take advantage of your position as the chairman
Hmm.
of a scheme for having a toilet and immediately you file an application, get an area settled, allotted to you?
No, my lord.
How did the right accrue upon you? How were you selected?
My lord, that is they knows better.
No, they
Even
not
my
know
lord,
better.
My lord, I am the chairman
You-
of the market
You file,
committee.
you are
I
chairman,
applied
you file an application,
Hey,
get
I
an order
filed-
of the executive officer, get
Ex-
yourself selected.
executive officer is selected me. Rightly
no
or wrongly?
No fault of yours.
What is my fault? My lord, kindly see my application, my lord.
Your
Kindly
time
see
has
the-
also expired.
No, my time is because of the long pending of litigation, my lord. Kindly see, my lord, my
Mr. Das, this
application.
is an equitable jurisdiction. You cannot say I am not at fault when it is allotted to me. Why did you take the allotment without a public participation? What is your answer to this? That I am not at fault. The fault is on the executive officer to give me the allotment. You should have refused to take the allotment. What kind of response is this? I do not know why is it given to me.
No, my lord.
We are
as a
open. Our
public-
eyes are
as a-
open. What is going on?
Understand, my lord.
Application, man.
You file an application, get the allotment, and when the public complains, you say principles of natural justice violation. What is this kind of a equitable jurisdiction?
As
Sorry.
as a my lord, kindly see my lord, my application, my lord, for page 30.
We have found another big fault on your part. You are chosen as a chairman for a public purpose. You took advantage of the position. You took allotment of a land of the same area.
No, public public as a
And did you
chairman-
disclose? Did you disclose this in your writ petition? That you are the chairman of the scheme?
Yes, my lord.
Only in the reply affidavit, in the writ petition, did you
Yes, my lord.
disclose?
Yes, my lord.
Disclose. Let us
No,
see where have you disclosed.
No, I have not disclosed.
Sorry.
My lord, but
if you come to a court of equity, you have to come with clean hands, not like this. Don't expect any relief from an equitable court with this kind of a conduct.
My lord.
You are
even-
raising some problems with the signature of even if we ignore all those and admit that this affidavit is not entitled, then also you do not have a case.
My lord, being a public, I have a right to apply, my lord, for the construction, but the,
And the advantage you got because of the chairman,
the chairman for construction.
you have
my
got
lord.
the right to
I have
apply. Now,
constructed.
once that thing has come before the court, court will examine.
Yes,
If
my
you have
lord.
got it by the back door, you exit by the back door. Matter over. Yes, the instant writ petition has been filed challenging an order dated 9/5/2024 issued by the executive officer Boitamari Anchalik. What is Anchalik Gaon Panchayat? Either it's Gaon Panchayat or Anchalik Panchayat.
Panchayat.
Huh? Mr. Das?
Yes, my lord. Anchalik Panchayat. my lord.
Why have you written Anchalik Gaon Panchayat? Mr. Doctor, what is it? Anchalik?
Anchalik Panchayat. my lord.
Anchalik Panchayat,
Boitamari Anchalik Panchayat.
whereby the allotment of land for construction of shop, which was given to the petitioner via order dated 19/4/2024, was stayed. Full stop. The principal ground of challenge is violation of the primary ground. The primary ground of challenge is violation of the principles of natural justice. Full stop. Para. I have heard Sri N.C. Das, learned counsel for the petitioner. I have also heard Sri S. Datta, learned standing counsel PNRD, as well as Sri who state counsel?
Gogon Bokolial.
G. Bokolian, learned state counsel. Para. As per the facts projected, comma, wide and order dated 19/4/2024, the petitioner was allotted an area to construct shops for business on temporary basis for 2 years. Full stop. However, immediately thereafter, the impugned order dated 9/5/2024 has been passed by staying the allotment order. Full stop. The petitioner claims to have filed representation on 15/5/2024 to revoke the stay order and no action been taken, comma, the petitioner had approached this court by the present petition, in which this court vide an order dated 31/5/2024 had granted an order of status quo. Full stop. Para. Sri Das, the learned counsel for the petitioner, has submitted that in spite of the order of status quo, there was activity of digging of a well for which an additional affidavit has been filed by the petitioner. Full stop. He has submitted that a right had accrued upon the petitioner wide issuance of the allotment order dated 19/4/2024, and that right was taken away without affording any opportunity to the petitioner. Full stop. He has also questioned the authority of the respondent number 4 in filing the affidavit in opposition by submitting that the deponent was not in office on the date of presentation of the affidavit. Full stop. The learned counsel has submitted that a rejoinder affidavit was filed on 21/5/2026, raising the said issue. Full stop. In the rejoinder affidavit, however, it has been disclosed that for execution of a scheme for providing running water and toilets, comma, the petitioner was appointed as the chairman. Full stop. Para. Per contra, comma, Sri Datta, the Learned Standing Council, PNRD, has at the outset submitted that as on today, there is no live cause of action inasmuch as the allotment was for 2 years, which had expired in April 2026. Full stop. He has also submitted that the petitioner had taken advantage of his position as the chairman of the committee pertaining to the scheme, and the allotment order dated 19/4/2024 would itself disclose that the same was done without any public participation and merely on the basis of an application made by the petitioner. Full stop. He has submitted that immediately on knowing about the same, comma, there was public complaints which had required a temporary stay, which was done on 9/5/2024. Full stop. He has also submitted that the matter was looked into and vide an order dated 31/5/2024. The allotment itself was cancelled, and this cancellation is not the subject matter of challenge. Full stop. He has also submitted that no application for amendment of the writ petition or any new writ petition was instituted challenging the order dated 31/5/2024. Full stop. Para. The rival submissions have been duly considered and the materials placed before this court have been carefully examined. Full stop. Para. The allotment order dated 19/4/2024 clearly discloses that the same was done without following any due process of law. Full stop. Distribution of state largesse has to be preceded by a procedure so as to give equal opportunity to all eligible and interested persons, so that transparency and fairness can be maintained, which are the hallmarks of such as of a system of such distribution. Full stop. It is also revealed that in the writ petition, comma, there was no disclosure of the material fact that the petitioner was the chairman of the scheme pertaining to construction of toilets and drinking water facilities, which came to light only on filing of the rejoinder affidavit. Para. Be that as it may, comma, the allotment by the order dated 19/4/2024 was for a period of 2 years, which was immediately put to stay by the impugned order dated 9/5/2024. Full stop. Though the learned counsel for the petitioner has emphasized that there has been violation of the principles of natural justice, comma, this court is of the opinion that the order dated 9/5/2024 was temporary in nature, which had to be passed on public complaints. Full stop. It, however, also transpires that subsequently the cancellation order has been passed on 31/5/2024, which is not the subject matter of challenge. Full stop. Para. Considering the entire facts and circumstances, and also the fact that the period of allotment is already over, comma, this court is of the opinion that no relief whatsoever can be granted to the petitioner. Full stop. this court also this court observes that the aspect of approaching the court by the petitioner with clean hands have not even been gone into deeply by this court. Para. Writ petition accordingly stands dismissed. Yes. Yes, Mr. Bhuya.
My lord, in fact, initially they did not dispute. A bill had been generated, my lord, and later on, my lord, they have raised that some false bill had been implicated, my lord. I have inserted as an agent.
Hmm.
So, my lord, as they have not admitted and disputes has been raised, my lord. So, my lord, some adjudication is required, my lord.
The amount that was otherwise due as per the APDCL's calculation, those amounts have been paid. Way back in the year 2022, in fact.
Now what is your difficulty, Mr. Bhuya?
Lord, the difficulty is that according to the bill prepared, my lord, initially at page 51, my lord, is amounting to rupees 25 lakhs, 34,084 rupees. Now, my lord, by the impugn order, is at page, my lord, 70. But they have said that this amount is not correct. So after deduction, my lord, I am only entitled to an
Pay,
amount.
not entitled. You are liable to pay.
My lord, at page 71, they are saying, my lord, net payable by APDCL to franchisee. And I am the franchisee, my lord.
Okay, so they'll pay you. You are the franchisee.
I am
Okay.
the franchisee, my lord.
Oh.
Rupees only 2,52,383.
Okay.
And now in the affidavit which they have filed, my lord, they have disputed in paragraph 11, my lord, at page 81, said that, my lord, the certain host consumers and non-existent consumers, disconnected consumers, my lord, I had, my lord, in the bill, I had
You have raised,
incorporated.
inflated the bills.
Inflated the bill, so that is not correct and that cannot be paid, my lord. That is the issue at this moment.
How do you adjudicate?
That is the issue, my lord. I have to.
How much amount are you admitting?
The admitted amount has already been paid.
Paid. For the rest, you approach the civil court then.
My lord, I think so, my lord, because.
Otherwise, more time will be wasted here.
My lord, because, my lord, these evidences which we have relied, the consumers, we can take the evidences of those persons, my lord. But here it will be difficult.
Heard 3A R Bhuya, learned senior counsel, assisted by, yes?
N.J. Chaudhary.
N.J. Chaudhary for the petitioner. Also heard 3B Chaudhary, learned standing counsel APDCL. Full stop. Para. The instant writ petition has been filed with the following prayer to court.
Page
20, 23, 22. The London Senior Council has submitted that there is an arrears of bill extending to rupees 20,96,199.29 to be paid by the APDCL to the petitioner who is a franchisee. Full stop. On the other hand, 3 Chaudhary, the learned standing counsel, has submitted that the matter has been examined and the bills are found to be inflated. Full stop. However, there is an admission to the extent of rupees 2,52,383, which have already been released to the petitioner.
On 28/6/2022.
On 28/6/2022. Full stop. Para. On para now, he has also submitted that inflated bills have been raised by inserting names of non-existing consumers. Full stop. Para. The aforesaid projection has however been stoutly disputed by Sri Bhuya, the learned senior counsel. Full stop. He has, however, fairly submitted that since the issue would be in the realm of disputed questions of fact, comma, he may be allowed to approach the appropriate civil court for redressal of his grievance, wherein the scope of adducing evidence would be available, full stop, para, in view of the aforesaid submission and the facts and circumstances, comma, the instant writ petition is closed by giving liberty to the petitioner to approach the appropriate civil court for redressal of his grievance so far as the balance amount is concerned. And if such approach is made, comma, the same is to be adjudicated strictly in accordance with law.
Only if any delay may come.
Bills of which year?
20, the last impugn order is of 2020.
2020?
Impugn order is of 2022,
The petitioner would also be at liberty to file appropriate application by invoking section 14 of the Limitation Act 1963 for condonation of any delay in instituting the case, which is
Obliged.
considered in accordance with law.
Obliged.
Seven,
Matter pertains to non-payment of dues, your lordship. In
non-payment of
dues, your lordship. In affidavit, they have admitted the amount, and I have instructions that some portion has been paid recently, your lordship. I have to take instructions regarding the actual amount, but not the entire.
We'll close this then. Okay, and Mr. Atreya, you for whom?
Respondent to BTC. I pay for BTC.
BTC, okay. Heard Sri B.J. Mukherjee, learned counsel for the petitioner. Also heard Sri Mukolia, learned state counsel, and Sri Atreya, learned counsel for the BTC. Para, considering the subject matter and as agreed to by the learned counsel for the parties, comma, the instant writ petition is taken up for disposal at the admission stage. Full stop. The issue is with regard to a claim for release of contractual dues. Para. As per the facts projected, please have a seat, Mr. Mukherjee. As per the facts projected, comma, the petition number 1 is the proprietor of the petition number 2 and is a contractor who was awarded several works for supply. Full stop. The said several works, including supply works. Full stop. It is claimed that the works were duly completed and a bill was raised of rupees 90,63,697, which was not paid, and accordingly the instant petition was filed. Full stop. Para. In the affidavit in opposition filed with respondent numbers 4 and 5, comma, the amount, however, has been admitted. Full stop. Para. 3. Mukherjee, the learned counsel for the petitioner, has also informed this court that in the meantime, certain amounts have been released. Full stop. Para. The scope of interference by a writ court in claims for contractual dues is limited. Full stop. However, the limited as it constitutes disputed questions of fact. Full stop. However, the Honorable Full Bench in the case of Tamsir Ali versus so-and-so has laid down certain principles wherein a writ court can issue directions, and one amongst the principles is an acknowledgement in writing of the liability by the chief engineer oblique head of the department. Para. In the instant case, comma, in the affidavit filed by the respondent numbers 3 and 4, comma, there is an admission of the liability. Put up for ready reference, comma, the averments, relevant averments are made in paragraph 3 of the affidavit, which are extracted here in below. Para. In view of the above position, comma, this court directs that so far as the balance amount is concerned, comma, the same be released to the petitioner by following the principles laid down in the case of Tamser Ali. Supra, full stop. Such release be made expeditiously and in accordance with law. Twelve and 13. ICCO, what is ICCO? A.K. Sharma. D. Chaudhary.
Yeah, please, Your Lordship, we have already returned the brief.
What is your name?
H.J. Tamuli.
Oh, you are not in the case.
At present, we are not in the case.
Oh, you did any idea of the deposit? 10 lakhs? No idea.
No instruction, my lord.
Okay. Sri H.J. Tamuli, learned counsel, has submitted that the brief has been returned to the clients. Mr. Mohanta, are you there in this case?
I filed my wakalat namas today. Well,
Have you deposited the amount?
no, my lord, there's one serious predicament faced by the petitioner, my lord. What had happened was, I'll just say very brief.
Have you filed any application?
Yes, I'm not pressing that application.
No, you have to, predicament, you have to place it before on record.
No,
There's a
Lord,
direction of this court to pay 10 lakhs.
I have instructions to withdraw the matter. My lord. What had happened, my lord?
Then you withdraw it.
Yes, this shed was allotted, my lord, in the year 64, my lord, 1964. And there are some issues regarding the rent. A demand of 99 lakh was placed, my lord, and I cleared 50% of the amount while the matter was pending. 50 lakhs admittedly paid, my lord. Now, during the course of...
Take your seat for 1 minute. You are short of breath.
I'm so sorry, my lord.
Take your seat.
Yes.
We'll hear you after 2 minutes.
Yes.
At the outset, Sri H.J. Tamuli, learned counsel, has submitted that the brief has been taken back by the client. Full stop. At this stage, Sri P. Mohanta, learned counsel, has appeared and has submitted that he has filed he has filed the wakalatnama. Full stop. Sri Sharma, Sri Mahanta, the learned counsel, however, submits has also informed that I 2120 of 2026 was filed, which, however, he would not. He did not file. No? Has submitted that IA 2120 2026 would not be pressed by him. Full stop. So far as the writ petition is concerned, the learned counsel has submitted that he has instructions not to press the same.
Seeking liberty, my lord.
Same. Full stop. However, he has sought liberty to present afresh.
Not afresh, my lords. There were some issues regarding calculation of the amount, my lords.
So
For that,
liberty
this
for
court
what?
cannot adjudicate. my lords.
Liberty for?
Liberty for, my lords, if they want to take any measures, my lord, they have to do as per law because they have to follow the PP Act, my lords, the Public Premises Act.
No,
It
what
is-
liberty will you seek now?
My lords, to approach the civil court my lords, for the calculation.
It's a liberty to approach the appropriate forum.
Appropriate forum.
Writ petition according to stands dismissed on withdrawal with liberty as prayed for.
And the court shall not be prejudiced with any observation made here, my lords.
We have not made any observation.
In the orders, my lords, in the other orders.
Not.
50 lakhs has already been paid, my lords. of the-
Oh, no, you will not say anything here. Close.
Diploma.
Do it. Both the writ petitions will go?
Both the writ petition.
Okay.
These two matters were vehicle bills for that. In item number 14, we have not received any instruction yet. But in item number 15, we have instruction.
14 and 15 are connected.
Not connected, Lordship, separate matter.
For 15 we can take. 14 will have it so far as 14 is concerned, huh? On the prayer of Sri G. Bokolial, Learned State Council, matter is adjourned by 3 weeks
Well,
to enable him to obtain the instructions. List on 1, 2, 3. We will have it on 10th of August.
Macho.
And the other one?
the one bill is admitted, however, some excess amount the petitioner has claimed. So we will file affidavit in this one. Or on the basis of instruction, lordship can dispose.
You file an affidavit. Your name? What is your name?
JK Bhuya.
Out Sri J.K. Bhuya, learned, good kiss play diba. Sri J.K. Bhuya, learned counsel for the petitioner is present, bully for last slide. Itu dire likhiba. 1119 not likhiba. Item number 15. Out Sri J.K. Bhuya, learned counsel for the petitioner. Para. Sri G. Bukolial, learned state council submits that instructions have been received as per which comma, though there is some amount due, comma, the amount claimed by the petitioner is the same is less, due, comma, the petitioner has claimed more amount. Full stop. Para. Be that as it may, let an affidavit be filed by the respondents.
Macho.
Para. List on, we'll have it on 14th of this August. 14 August.
Macho.
I'm sorry, my lord, I am in respondent in item 12 and 13, lordship.
Okay, 12 and 13. We can require your name. What is your name?
MM Zaman, lordship.
Zaman,
lordship.
Zaman.
For
On-
AIDC, lordship.
For AIDC. দুইটা লিখিবা শ্রী এটাই কেস এটাই অর্ডার শ্রী MM Jaman, learned counsel for the AIDC is present. We have closed both the petition giving liberty.
Lordship.
16.
Made to the lordship. So in this matter for respondent, learned AG is appearing, representative is appearing. For some personal difficulty.
AG is not appearing.
Senior counsel.
Senior counsel is appearing. How can AG appears for oil?
Senior counsel, Devoshik is appearing.
Okay. You had taken time for today.
That's right.
Urgency was expressed by them.
Yes.
Yes, lordship. For personal, he was here in the court. For personal
Okay.
difficulty, he had to leave the court. He has requested, he has informed me that if your lordship will otherwise find it not inconvenient to the lordship, can it be taken on Wednesday, Tuesday, lordship?
Lordship, may I
Yes,
suggest?
Yes.
Let me start.
No, we don't do on piecemeal basis.
He has to hear the.
No piecemeal, no piecemeal.
No, you have more time to prepare for reply. If
No,
I ask you
start,
today and you come
start,
back on
complete on
Tuesday.
the same day. We don't do in piecemeal, whenever you say.
Tuesday,
Lordship,
if your lordship
Tuesday is
not
the
inconvenient.
earliest.
What is the matter, madam?
Lordship is debarment. We've been debarred by oil from carrying on business with them for two years. 1 year is already gone. 1 year is already gone.
Opportunity granted. Opportunity granted,
Our complaint is not adequate opportunity.
not adequate.
They've given a show cause notice. We asked for documents and personal hearing, which we didn't get. We've gotten now in course of affidavits filed in court, not before the debarment and banning order. That's one ground. Other ground is condition precedent is not met, and they have debarred us. And there is one more ground which we will disclose when I argue.
You have it in your sleeve.
Yes, Your Lordship.
Will not put your cards open now.
Keep your powder dry. Let's see. 1 or 2 works, then we will not have to go to that one.
But if you are given opportunity, can you go to the adequacy of the opportunity?
Which is why, Lordship, that is one of the grounds. There's a more
See,
important.
no opportunity is another matter. Opportunity, how much opportunity? That's another matter.
Agreed, Your Lordship. Yes.
And if they have met Eurasian and Gorkha and all the principles, then scope is less. But you
Lordship may
still,
hear me. Lordship may hear me.
and the scope of person, here
So is also on very
slightly vague and appropriate.
Gorkha says not required.
Not
So
required.
I understand, Your Lordship. But
On Tuesday.
But opportunity, yes. Opportunity, Eurasian has made very clear.
yes.
One of the first cases.
Yes. And Eurasian was actually bribery and malpractices, and notwithstanding that, they said you have to give an opportunity.
And Thakur also, Ranjit Thakur.
Yes, Your Lordship. That's right.
Okay, when?
Tuesday also.
Tuesday.
Lordship, may I make a prayer? Can it be higher on board? Because after lunch, again, it might be a.
We do not know. After lunch, no problem with us. The problem
Lordship,
is
no problem with.
problem is with you, madam.
No, Lordship, not problem. I have never asked for
You means
accommodation.
not you. You means the bar members.
Yes, now that, which is why the prayer, Your Lordship.
You means maybe the other side, maybe your side.
Not my side, Lordship.
We are there. We have to be there till 4:30. We cannot have the liberty and
Which is why,
luxury,
Lordship,
to leave the court.
Lordship may hear me today, and I
No,
make
no, no,
that
Pismil.
easier.
No, Pismil. Tuesday. Okay.
Lordship, high on board.
We cannot say that. You make a request, we'll try to accommodate. Heard 3G Goswami Learned Senate Council for the petitioner. Para 3A Sharma Learned Council for the OIL has, however, made a prayer for accommodating 3D Saikya Learned Senate Council who would appear for the respondents. Para. As agreed to by the learned councils of the parties, list for admission hearing on Tuesday. Board matters,
Lordship.
Series.
Let it be there.
You take it on Wednesday. Motion days matters get over very soon.
All right, Lordship.
We'll have
keep
it on
2 o'clock.
We'll not say anything.
Lordship, one moment. Wednesday is
Wednesday is Wednesday.
22nd. 22nd.
Cannot be any other day. 22nd. Okay.
Keep Wednesday, Your Lordship?
Yes. 22nd.
Wednesday is okay with.
I do not know. My instruction was for Tuesday.
Then have it on Tuesday. Otherwise,
Yes.
if Mr. Saikya has a problem again.
We'll make an.
Okay.
So therefore,
If it doesn't reach on Tuesday, then at least there's Wednesday.
then their mention can be made on Tuesday.
Okay, Tuesday then, 21st.
Obliged.
Obliged.
Lordship, we have, on behalf of the PWD, we were supposed to file an affidavit. Lordship, we have sent in for within just 2 days time, Lordship.
Mr. Ullah, what is this matter about?
Lordship, we are L1 Lordship.
In a tender process?
Yes.
Thereafter, not given?
Thereafter, after 6 months, they are not doing and they again cancelled and face
Gone
tender.
for retender?
Yes. It was on the second time I was L1.
What is the work about?
The work in respect of the construction of the medical ward at Gauhati Medical College Hospital.
Why have you want somebody else?
No, Lordship, after evaluation of the technical and financial bill, the recommendation was forwarded to the government for approval. We didn't receive back any approval. So as per clause 4.1, we had to cancel it and again reissue the same tender.
You want somebody else?
Lordship,
Not him.
we didn't got the approval for that particular year.
Without informing us, without getting any show cause to us, anything. This even on the website also it was being published that we are
You have
L1.
to cite reasonable grounds.
Yes.
You cannot reject his or decline only because of some other irrelevant conditions. If you have evaluated his technical responsiveness, found him to be technically responsive, how many bidders were there? Was there a fair competition? There was. Mr. Ullah, there were the competition.
Second time, two bidders
Two bidders.
on second.
First time what had happened?
This lot.
Second time it had happened.
Yes, Lordship. Two bidders.
First time?
And technically, Lordship, we are not available, Lordship. It's not available, Lordship. But on the second time, the other bidders were technically not fit, and I was technically fit.
You need a medical building as soon as possible. There is a person who has expressed his interest. You find him eligible. You select him, then you don't give the work to him. Okay, you file your affidavit. How soon? Next week?
Lordship, next week.
Next week? Okay. Heard Sri B. Ullah, Learned Counsel. For the petitioner, footstep Sri B. Chaudhary, Learned Standing Counsel, Public Works Department, has submitted that the affidavit in opposition has been prepared and sent for vetting. Footstep, he accordingly prays for a short time to file the affidavit. Para. List on a matter is accordingly adjourned to be listed on when? 27th?
This one.
27th of July 2026, by which time the affidavit is required to be filed. Para. Interim order passed earlier to continue till the next date of listing. What is the interim order?
No, Lord.
What is the interim order?
Yes, Lordship. Nothing to be.
Not
Although they have received the tender, but it is not to be finalized.
Okay.
Instructions.
19, what is it?
Requested to make an inquiry lordship and submit a report.
Enquiry done.
No lordship, not yet. The works undertaken was falls under the non-permissive city.
Have you filed the affidavit? Not filed. Oh. What is your name?
J. Abbas.
J. Abbas. Heard Sri J. Abbas, Learned Counsel. Your name is not there, Mr. Abbas. Oh, it's there. J. Abbas, Learned Counsel for the petitioner. Para. Ms. P. Thapa, Learned Counsel representing the Panchayat and Rural Development Department, has submitted that vide a communication dated 21/5/2026, the commissioner of the department had directed the district commissioner, DPC, MG Enrega, South Salmara Mankacha district, to make an inquiry and submit a report. Full stop. She has submitted that the inquiry is not yet over and accordingly prays for some time. Para? We grant some time. List after 4 weeks to enable the Learned Standing Counsel to place on record the outcome of the inquiry. Para? List on, we give a date. List on 17th of August. Letter district DPC Yes, Mr. Das.
Yes, Lordship, in this matter, my senior Mr. K. Chaudhary would like to appear. However, Lordship, I'd like to point out certain facts, Your Lordship, before he joins Lordship. Lordship may come to the writ petition, Lordship. The impeachment order was issued on 4th of April 2026.
Oh, other side, yes.
State is there, Lordship. The Mr. Dinat is appearing, Lordship.
Let him come because we had made an observation that an endeavor would be made to finally dispose of the writ petition.
Because 3 months of lordship elapsed, lordship. However, my suspension is still there, your lordship.
This is under the 1982 orders.
Yes, lordship.
Come on, Asadi.
Lordship, last 1982 order, lordship, is clearly states that lordship after 90 days.
1982 the supply order এখন এটা হবে। এইখানে আছে নেই। এইটো ফাইলত নহয়, এইটো ফাইলত নাথাকে। আমাৰ ওলোৱা আছে। আমাৰ ওলোৱা আছে বেলেগকে। এই লগত ফাইলত নহয়। ফটোকপি কৰা আছে। তাৰ তলৰটো চোন নেক্সট হেৰি এইটো 82 সেইখন কি ডাঙৰখন কি? আছিলে এখন পাব্লিক হেৰি সেইখন লৈ থৈ দিব লাগে। Assam Trade Articles within bracket Licensing and Control Order 1982.
Yes. If lordship may. Lordship, I have a copy, your lordship. Look. Lordship, the page number is not there, lordship. May come to clause 11, your lordship.
Now, what are the facts?
Facts, lordship.
Who are you?
Lordship, I am a gas agency distributor, your lordship. LPG cylinders distributor under the IOC, your lordship.
Yes.
Lordship, without giving any opportunity, lordship. Page number 21, your lordship. It's an order dated 4th of April 2026.
21.
Page 21, lordship, of the writ petition.
Where do you get the date?
Lordship, it's in the second page, page 22, your lordship.
4,
April
4,
2026.
26. Yes, what happened on 4/4?
So the whereas, lordship, whereas the credible reports and complaints have been received against the petitioner. alleging-
Message Nabojyoti is the petitioner.
Yes, lordship, this MS Nabojyoti Gas Agency is the petitioner, your lordship. Alleging serious irregularities in the distribution of LPG cylinders. And whereas upon detailed inquiry and field verification, it has been prima facie established that the said agency has falsified so and so, these are the allegations. And whereas such act constitute grave violation of the provision of the Assam Trade License Lordship Order. Clause 9, breach of license conditions. Clause 8, empowering the license authority to suspend or cancel so and so. And whereas the LPG being an essential commodity and resources so and so, lordship. So next para, lordship. Now therefore, in excess of powers conferred under clause 8 of the Assam Trade so and so order, read with relevant provisions of the Essential Commodities Act 1955, I, the District Commissioner, Kamrup Metro, hereby order that the trade license of MS Nabojyoti Gas Agency, Hatigarh, Tiniali, Gauhati is hereby suspended with immediate effect until further orders. The agency shall immediately cease all operations, including booking, storage, and distribution of LPG cylinders. This order is issued in the interest of maintaining transparency, ensuring equitable distribution of the essential commodities and safeguard the public interest. Lordship. So thereafter, lordship, the state has filed their affidavit annexing certain complaints, but which has not been substantiated by them, your lordship.
You are aggrieved by the suspension order?
Yes, lordship.
What are your legal grounds?
Lordship, firstly, lordship, without giving any opportunity, lordship, my suspension was done, lordship.
Is it required?
Lordship,
For
whatsoever,
suspension?
lordship, apart from the lordship, the principle of natural justice should have been followed, your lordship.
Now, section 8, is it required that you are
Lordship,
order 8, clause 8?
Clause 8, lordship. power to refuse license.
I think it's wrongly quoted. Suspension is 11, it should be.
Exactly, Lordship.
It
It's
doesn't
wrongly
matter,
quoted.
11.
That also shows the non-application of.
Doesn't
9, Your
matter,
Lordship.
non-quoting or misquoting will not make it
Lordship, whatsoever, Lordship.
per se illegal.
But they have said, Lordship, let's come to clause.
Let us come to the suspension clause.
Suspension clause 11.
11,
Lordship,
yes.
11. If any license, so licensee, Lordship, it should be licensee, or his agent or servant or any other person getting on behalf contravenes any of the terms and conditions of the hence, then without prejudice in any order.
It should be, it should, of the license,
Yes, Lord, license.
of the hence. I think it's wrongly typed or wrongly.
type. Some mistake, Lordship.
Then without prejudice to, আমার কপি কোন কোন বল আচ্ছা আছে উল্লো আছে ফটোকপি কিন্তু কথা কিন্তু তলত আছে এইবিলাকৰ তলত যে আছে এইবিলাক ওইখিনি তলত আছে বহুতবাৰ আগতে কৰিছে ডাঙৰ ফটোকপি আছে Okay, then without prejudice to any other action that may be taken against him under
The essential commodities
may be cancelled.
may be cancelled. An order in writing of his licensee of the licensee authority, and an entry will be made in his license relating to such suspension or cancellation.
So this is cancellation.
Yes, Lordship. This is suspension or cancellation. I'm with suspension, Your Lordship. Next, Lordship, subclause 2. No order of cancellation shall be made under this clause unless the license.
I think there are some error in printing.
Lordship, may I have the book,
Local
Your
action rules of 1982. It's Assam trade. Local action 82 series. 21 number. Quit আছে অকল সেইটো 21 মোক দেখুৱাই ল'বচোন 11 or 11 section order 11 suspension. So under subclause 2, there is a stipulation of 90 days.
Yes, Lordship.
Okay, ভুল কে ভেরি করা আছে same issue. Okay, well, is it your case that this 90 days are over and no
It's
action?
one of the ground, Your Lordship, because by the time, also on 4th of July, Lordship, 90 days has been lapsed, Your Lordship, and the state is not doing anything, Lordship. We have made
90
several communications to the IOCL authorities as well as the state.
On 4/7/26, 90 days expired.
Expired, Your Lordship.
And any action taken for cancellation?
Lordship, not yet, Lordship. That is no development, Lordship, from the state.
On this ground itself, you restore the license.
We have not taken any disciplinary action from our end. Till the trade license is revived, we cannot take any action. We cannot deal also.
Okay.
So we are dependent on the action.
Yes, Mr. Have they filed an affidavit? Have you filed affidavit?
Yes, Lordship.
But 90 days, if it's over, then maximum is for 90 days. It has to be restored. Then you can take action. That's a different matter.
Licenses cancellation order has been passed.
Passed.
Maybe Lordship. But
What is your instruction?
Litigant-in-person we have to
Any information by your client?
No, Lordship. Let it come after some time, Your Lordship. In the meantime, Mr. Dinath will also arrive. Your Lordship.
See, subjective matters we may not go into, but there is an objective
Yes.
fee set where we can look into. If 90 days, if it is over, then okay, after a while. Proper read, গোটেইখিনি নালাগে এবাৰ চাই ল'ম দিম লোকেল এক্টৰ পৰা চাব লাগিব সেইকাৰণে নকত কোনোবা খনত আছে We wanted to have this as new matters. Why didn't you make a mention of this matter in the morning? We said that we'll give this matter preference. Last time we had made this at least at 2 o'clock, if not at 10:30. Will it be possible to have it or complete it today? Not possible.
Not. On any other date, we'll make a mention on that day.
But next Tuesday and Thursday are all almost done. Thursday we can try.
Next
Thursday.
Next Thursday,
But we'll give preference immediately if there are motion matters.
Yes, sir.
Immediately after the motion.
23rd.
Even before the admission, we'll take up these matters.
Yes, ma'am. On 23rd, then,
In fact, we made an observation. Like, would be at liberty to make a mention of the
yes,
observation.
ma'am. That observation.
We expected some mention. Nobody had mentioned.
Now only when your lordship just pointed out.
No, we said that now we are seeing the order, but we remember saying this. Paucity of time may not permit these matters to be taken up today. On a joint request, matters are adjourned to be listed on Thursday. Thursday date to be Thursday. 23rd. We'll give preference to this matter.
Yes, ma'am.
Please make a mention.
If not inconvenient, may it be mentioned in the causaries.
Once this date is not within our thing, you make a mention.
Yes, ma'am. Oblige.
Where is Mr. Nath? Mr. Chaudhary is there. We could have taken up his matter. There's some oral instruction, perhaps it has been cancelled or something. Mr. Kolita he also doesn't have concrete information.
Oh. At least till yesterday evening, Milord, there was.
Because we'll not go into, we have indicated, we may not go into the other aspects of your argument, but 90 days is a objective satisfaction which we can, if it's not done, we'll ask for restoration.
Yes.
For others,
And let them others proceed, Milord.
Mr. Nath has come.
Yeah.
Mr. Nath, if 90 days is apparently over on 4/7/26.
Yes.
If there are no other development towards cancellation, then you have to restore it. Unless you come up with a submission that it has been cancelled.
But some telephonic instruction, I don't have the detailed instruction. If Lordship kindly takes up tomorrow.
Tomorrow we'll have it.
Lordship.
But if it is not cancelled, then you have to restore. You can, without prejudice to your rights.
Yes.
But you cannot just indefinitely have it for after 90 days. That is the mandate of law.
That is one, and number two, Milord, consequences which has ensued is worse than, Milord, cancellation.
Okay.
Kaila.
Heard Sri K. N. Chaudhary, Learned Senior Counsel, assisted by Sri D.J. Das for the petitioner. Para. Sri D. Nath, Learned Senior Advocate, Assam, prays for a day's time to obtain instructions on the status of the proceeding. Para. As urgency has been expressed and as agreed to by the Learned Counsel for the parties, list again tomorrow.
Can I prefer picking up?
Yes.
Whenever, we'll accommodate you, don't worry. এটা আগতে মাৰি দিব হা অলপ।
Kindly see the order date is 8/5.
Item number?
44.
Yes, contempt.
Lordship.
I'm taking a printout, my lords. I have a set of instructions, my lord. The budget head, my lords. Fund, there's no fund, my lord. We are seeking additional budget, my lords, for meeting up this demand. The chief engineer is written to the standing council, my lords, to apprise the court that as soon as the fund is, because on the last occasion also, we had fixed some fund, but it got lapsed.
Lordship, the issue here is, Lordship, the work orders are of 2010 to 2017, Lordship. And we filed a contempt on 2023.
Mr. Gogoi, we are not particularly concerned about our internal mechanism. We are concerned with the implementation compliance of the order of this court. Whether budget proposal was inadequate, not available, those and this matter is pending since 23.
23.
It cannot go on like this. We are in the middle of 26.
I understand, my lord. I also go down to that, my lord. My lord will give us some time for compliance. Because of this.
How will your submission be accepted? How much time? How much time? Until how long?
The clients are not able to answer that, my lord. We have been asking because it's
Then
also.
they'll have to answer in person.
No, let him come back.
They have to answer in person.
Let him come. Because
And not only answering, face the consequence. Consequence is very plain and simple under the 71 Act. If you do not comply, there are places where we can send.
I understand, my lord.
And that is what is required. Such luxury we cannot give it to you after compliance, after passing of an order of this court. 23 matters are yet to be complied with, and contempt matters you simply ask for time. Budget is not there, this is not there. You file an appeal, file a review, get it corrected if you think the orders are wrong.
No, sir, we are not.
Then if you have accepted the position, there's then finality.
There's no.
How do
denial
the
of-
system survive then?
There's no denial of any liability.
How do the system survive?
This court's order has to be complied with, my lord. That
We
we
don't
understand.
find any sadistic pleasure in initiating contempt proceeding on a 71 Act, sending somebody to jail. But if it required, we have to. Ask your persons to come, chief engineer,
My lord.
tomorrow.
Tomorrow. My lord.
And come him to prepared to be sent if it is required. Who is the chief engineer?
My lord, this new incumbent has joined. His name is Pallab Sharma. Pallab Kumar Das.
Not new. 24 he has joined. Who is the present chief engineer? Where is his name, Mr. Sharma?
That communication is there.
No, in the cost title.
What title, my lord? That point somebody else was there.
Ashok Dev Chaudhary was.
Diganta Borua, when it was filed.
You have not made the present incumbent a party.
No, Lordship, I have made Ashok Dev Chaudhary party. Ashok Dev Chaudhary was then party was chief engineer then.
No, now. You may make the incumbent a party. Why are you making things? If there's a change in incumbent, make them a party. Get your things expedited, not like this. See, without making a party will not, it will not be fair on our part.
Lordship, Lordship.
And before making a party, we have given opportunity, comply with the order. And unofficially, what Mr. Gogoi has said, that's unofficial. He's yet to be arraigned as a party. This will be injustice upon him if he's not a party and we say something against him. In the meantime, you also
I'll proceed.
look into the matter, try to get it settled, and you file an application.
Lordship.
Okay. Heard what Sharma you are?
DP Sharma.
Heard Shri BP Sharma, learned counsel for the petitioner, who has submitted that in spite of expiry of more than 3 years, comma, the order in question is yet to be complied with. Full stop. Para. 3. D. Gogoi, learned counsel appearing for the respondent, has submitted that all intentions are there for compliance, and in this regard, he has placed before this court written instructions dated 16/6/2026, as per which trust proposal for budget has been made. Para. While the steps taken, or while it may be the projected case of the petitioner of the respondents that steps are being taken, comma, the same would not mean that there has been complete compliance of the order of this court. Para. This court has, however, been apprised that there is a change in the incumbent, in the position of the incumbent made as a party respondent. Para. The learned counsel for the petitioner is accordingly required to take steps to implead the present incumbent. Para. It is needless to observe that the present incumbent is at first required to be apprised of the court's order requesting compliance, and only thereafter an impleadment application is required to be presented. List after 4 weeks.
Good. These are the series of contempt petitions, Your Lordship, with regard to forest royalty.
Something was done that was sent it to the treasury. You sent it to the treasury.
Yes, my lord.
I have been told that the residents.
Mr. B. Gogoi?
We have traced out even the amounts and the treasuries. my
No,
lord.
no, that last occasion we had said, made this. We want Mr. Gogoi, treasury, or anyone from the finance department.
Let us have one chance. I'll just try to.
Okay, we can close this. We can close this if it's before the treasury.
Let the money at least come, Lordship.
No, not without hearing you.
Yes, yes.
If it's come to a treasury, have the position of Mr. Gogoi and close this. Yes. Yes, Mr. Mahanta.
May I please, Lordship? Lordship, in this case, when challenging the labor court are dated 12/10/2018, my lord.
Award.
Award, my lord. Lordship, in a last occasion, my lord, Mr. Honorable Court directed to take some instruction on date of not received. Possible find the award at page 166.
What is the award about?
It is a
Mr. Das, you are for the workmen.
Lordship.
It was a reference.
Lordship.
Section 10 reference.
Lordship.
Let us see the award. At page
166, my lord.
166.
And operative.
Date of the award 12/10.
12/10, my lord. Lordship, operative portion of the award is at page 185, my lord.
Let us see the issues, whether the management of AMDC
Lordship.
was justified in dismissing three so and so from service if not. So three of the workmen were dismissed from service.
Lordship, what happened, my lord? The petitioner corporation is a government of Assam company. And accordingly, my lord, being a government of Assam undertaking, the petitioner company adopted the rules and regulation of the government of Assam, including 1964 rules, my lord. And these respondent workmen were employee of the corporation, and while they were working in the corporation, they subjected to development proceeding. Accordingly, show cause notice and as well as search sheet were served as per Rule 9 of the 1964 rule. And upon submission of their reply and having not satisfied, the inquiry against the workmen were conducted, and the search level against were proved, and their service were terminated. Subsequently to their termination, they moved before the government, appropriate government, and accordingly reference was made to the labor court for adjudication, and after adjudication, this award was passed. And during this adjudication award, all the relevant documents pertaining to the inquiry proceeding, including the three management witness were deposed before the labor court. And finally, after adjudication without consideration, labor court held that inquiry conducted was were ultra-vires. Accordingly, award was passed in favor of workmen. Also, interestingly, even a learned labor court went to held that the petitioner company by corporation being a government of some undertaking, the rule 1964 rule is not even applicable. That is the great ramification, because we being the government of some company, we are following, and with that regard, last order was passed, whether there is any board resolution regarding adoption of the rule. So may I read the operative portion of the award?
Yes, please. So your challenge is based on what grounds?
Based on basically two grounds. In this case, labor court held that because of not following some procedure in the inquiry, that was the main ground. And other ground is that since labor court held that this rule is...
No, leave aside the other ground. Even if it's 64 rules are applied or applicable or not,
Lordship.
Did you follow the procedure laid down?
Lordship. Only one thing that is lacking, recording of proceeding,
No proceeding was recorded.
Recording of proceeding. Otherwise, all the opportunity is given.
No, if you do not record the proceeding, from where do you get the satisfaction?
Lordship, their written submission statement, all these were submitted before the inquiry officer.
Will that be enough?
Lordship.
Inquiry officer has to record proceedings.
Lordship. That was lacking. And so far as that's why I am relying on judgment, my lord. And in that case, that issue has to be decided from the standpoint of prejudice, my lord.
From the standpoint of
prejudice, since they were not prejudice even during inquiry, only in before the.
Now, where do you get the satisfaction that the inquiry was fairly held, if the proceedings were not recorded?
Lordship, they appear participated in the even their cross examination. I annexed the cross examination, my lord.
Yes. Where are those?
Lordship, cross examination 158 to 164. My lord.
Was there a report of the inquiry officer?
Yes, my lord.
Where is the report?
Lordship will find at in respect of respondent number 1, my lord, at 59 to 61, and in respect of
Page 59.
59 to 61 inquiry report. This is the communication and inquiry report start from 60.
Thereafter, this inquiry was held, inquiry report submitted thereafter.
Thereafter, this inquiry report was communicated to the delinquent with opportunity to submit representation.
Okay.
And thereafter they submitted representation and after that termination order.
So what was the basis of interference by the learned labor code?
Basically labor code is view is that since this rule is not applicable and even is applicable, this procedure is not followed.
What procedure?
Recording of inquiry proceeding. Lordship will find at page 182.
182.
82. Paragraph 25.
Paragraph 25.
25. Admittedly, the corporation is a government of Assam.
No, leave aside this part.
Loss.
Even if you assume
Yes.
that 64 rules are not applicable,
Yes.
we have to see whether he had followed the principles of natural justice before you came to a conclusion that they should be removed from service.
Lordship.
In other words, did you give the adequate opportunity?
Lordship, adequate opportunity given me.
Did you hold an inquiry where they were given a chance
Lordship.
to participate, to adduce their evidence, cross-examine the other side witnesses?
Lordship.
And whether the inquiry report was given to them?
Yes, Miller.
If that was given to them, then how does it make a difference whether 64 rules are applicable
Yes,
or not
Miller. That is
applicable?
the main issue.
No, is it the only ground of
Interference. The lawful, that's why also I may be allowed to read the operative portion. Miller. 25.
26, let us fix. 26, it says that for argument's sake, if it is presumed
Lordship.
that the three workmen falls under the purview of so and so, then let us assume that.
Loss.
Then, please read.
For argument's sake, it is presumed that there is a the workman fall under purview of 1964. Then, where the proceeding of inquiry, where the statement of evidence of witness recorded by the inquiry officer as recommended by Rule 9(6) of the rules, the three workmen should challenge the inquiry report and the punishment imposed by the authority on them, but no effort made before this court by the management to so that the inquiry held against three workmen were fair, transparent, and without any flaw of rules and law. But all the proceeding, all the records were exhibited before the labor court. Moreover, as per Exhibit 4, there was a resolution of board, the Board of Directors meeting held on 17/7/2014 that the signatory of the petition, Exhibit 3, should be asked.
The witnesses, the depositions were not recorded.
Lordship, they were, as per the inquiry report.
No, the inquiry report has to be based on certain materials,
Lordship.
which the inquiry officers collects
Lordship.
or gathers during the inquiry.
Lordship.
What are the materials? You will examine the witnesses, record their evidence, cross-examination, and whatever documents they want to submit by way of exhibits, you will consider. And on the basis of that, you will prepare a report. You cannot prepare a report by just hearing somebody. You are a fact-finding body. You need to prepare your report based on depositions and available materials. No depositions were recorded.
Lordship, as per report, Milord, on their written submission, Milord, they have submitted written submission.
Who? The witnesses?
Witness as well as.
Now, the written, it can be given in written form,
Lordship.
just like evidence in chief,
Lordship.
where they're given a chance of cross-examination.
Lordship, as per report, that is says so, Milord.
Cross-examination given.
Lordship.
Let us see the report. Mr. Das. See, we may not go to the aspect of applicability or non-applicability of the 1964 Act. That is besides the point. We want to only ensure whether the principles of natural justice has been followed, whether fairness, transparency has been followed.
The conclusion of the labor code is very clear. They have concluded this domestic inquiry was not There is no domestic interest, there is no departmental inquiry.
But what about the inquiry report?
Inquiry report was they have prepared on their own without any basis. There it is very, they have, from their cross examination also, from their evidence also, that the inquiry officer has not recorded any proceeding.
That is the.
They have not recorded statement of the
From
evidence.
where do you make this submission?
Similar case was 2 years old, I think.
This report which Mr. Mohanto is referring to of the inquiry officer.
In first, in respect of respondent one, there is no witness, my lord. Only one witness.
No, there is no witness before the so-called.
No, so far is other three. There are in the inquiry report mentioned about the witness recording of examination of witness.
Where is that copy? There is no.
Also,
they
I
haven't
have
submitted any copy.
I have annexed all the document in my evidence, my lord. Perhaps that is in the record, my lord. I've been
No, that record is record was given. Mr. Das, please have a look at the record.
There is no inquiry proceeding.
Mr. Mohanto or Mr. Das, let us be very clear.
Lordship.
There is no
Whether
inquiry-
64 rules are applicable, not applicable, applied, not applied, we want to we want to ensure that whether a fair procedure
Yes, my lord.
was undertaken before you took a decision to dismiss them.
Lordship.
What is a fair procedure is to give them an opportunity, proper opportunity. Now, if there is an allegation against them, you have to prove those allegations.
Lordship.
And prove, how do you prove? By witnesses whose statements are to be recorded.
Lordship.
It can be a pre-recorded statement, no problem. But cross-examination has to be given.
Lordship.
Was it done?
As per their cross-examination, Lordship will kindly have a look, my lord.
Page?
Page 158, my lord. That is the cross-examination of respondent one, my lord.
Oh. Prakash Varman.
Prakash Varman, respondent one. That I have not produced any documents showing that I was permanent employee of so-and-so. I received the so-called notice. I do not know how to write and read, but I can put my signature. I file written reply against the so-called notice. I send the so-called notice to my son Jagdish Varman, and he prepared a so-called reply and send the same to the authority. I cannot say what was written in the said reply.
Mr. Mohanto, we are more interested in the cross-examination of the management witness. Since you are for the management
Lordship.
and you are aggrieved by the award.
Lordship, management will cross-examination will find Lordship will find at page 41. That is
41.
141, my lord.
141.
141. MW 1, my lord. Cross-examination Solendra Goswami. I am presently holding the post of Superintendent of Assam Mineral Development Corporation. AMDC is a registered company and a state government undertaking. There is a board director.
It is there, Mr. Das. Examination, cross-examination is there. Examination, cross-examination is there.
In the departmental inquiry, there so-called inquiry, there is no proceeding. The inquiry officer has not maintained any proceeding. He has not taken any statement of the management witness.
No, this cross-examination is on the basis of what?
This is before the labor court. From here, Lordship will gather the whether inquiry, how inquiry proceeding was.
Oh, this is before the labor court.
Before the labor court. Before the labor court,
Even-
they adduce evidence. And their evidence also, their witness also categorically admitted that there is no inquiry proceeding was maintained. In the inquiry, no witness of the management is examined. No witness from the workman side also.
But will they be debarred from approving their case in the labor court? They have done so. See, there would be two aspects. One is the fairness of the domestic inquiry. They might have failed in that. But that will not preclude them from leading evidence to prove their case before the labor court as the primary authority.
Yes.
This evidence at 142 this can be taken into consideration by the learned labor court, whether this would be sufficient to sustain the orders of dismissal.
The learned labor court categorically hold that they fail to establish any allegation against the court.
Then we can decide that issue.
Yes.
This is the domestic inquiry, we can.
Yes, what happened, the
yes.
fact is that their main allegation is that 52 employees of the corporation has submitted a representation before the government. There is some problems of the corporation and requested the government to inquire about inquire on this thing. And that was their allegation. The said managing director at that time, he held that it is a misconduct. That why you have submitted representation before the government. Because, and 52 workers were signed in that representation. Out of that 52 employees, they single out only 3 employees and terminated their service. And they initiated inquiry, but no inquiry proceeding was held. No witness was examined by the inquiry officer. Without examining any witnesses, maintaining any proceeding, he submitted one inquiry report on his own. And that is why the levels of category, the management has not conducted the department proceeding as per the 64 rule, man, hasn't.
No, that will take care of the first part.
Yeah.
That there was no fair domestic inquiry. What about the proceedings before the labor court, where they had adduced evidence on the merits of the case?
Yes, very good because they could not establish their case.
We'll examine that part, merits of the case. How many witnesses were there?
3 witnesses.
So let us see the witnesses. Well, let us see the written statements. Mr. Monto. Management written statement is at 109.
Lordship.
And workman written statement?
Lordship, in the data event, Lordship will have to take my evidence part record, my lord.
Yes, it is a part of the repetition.
Yes, yeah, no, my lord. Record is already.
Record corner. Evidence and cross-examination on the management side. Evidence and cross-examination on the workman side. Oh.
Lordship, even in the labor code, my lord, even there are 2 exhibits before the labor code. Even that 2 exhibits were not taken into account. Even labor code held that was not brought into the record of before the labor code. Exhibit 5 and 6, that was the main. Lordship, kindly have a look at page exhibit 5, my lord.
Now we want to have a look at the findings of the learned labor code,
Lordship.
which are based on the evidence which were adduced before the labor court on the merits of the case.
Lordship.
Because in the case of Ludbur, I think
Lordship.
it is said that if you fail on the aspect of fairness of domestic inquiry,
Lordship.
you can adduce evidence on the merits of the case before the learned labor court. That was done by 3 of the witnesses, management witnesses.
Lordship.
What is the finding of the learned labor court?
Lordship, then Lordship, allow me to read the judgment from paragraph 16, my lord. 16 or not, my lord.
No, 16.
16 or not, my lord. Paragraph 16, 117, my lord. 177. May I read, my lord?
Just a minute, please.
The fact is that already these workmen have already attained their age of retirement. Are already retired.
Oh,
Lordship,
Only issue remains now that the payment of back.
yes, my lord, because that was a huge amount, because three, as, and as per,
how much would be the amount now? Around?
Around, they will get gratuity. Gratuity, provident fund to provident gratuity, and some backwards.
backwards, my lord.
Not much, actually, they have also already got benefit under 17B also.
17B, so
We are
that,
compliant with
that burden is not there.
Yes, my lord.
Last wages drawn, you have been paid.
Yes.
So if you are reinstated, if we dismiss their petition, you will be entitled to retirement benefits.
Retirement benefit, gratuity.
Opportunity. But the findings at paragraph 30 and 31,
Yes, me.
does not seem to be consistent.
Yes, me.
Please come to 30 at
Yes, ma'am.
184.
Yes, my lord, it is.
184,
reference-
the learned Labour Court rightly
Yes,
discusses Ludbut Singh.
yes,
That if you fail on the domestic inquiry,
Yes.
fairness part,
yes, yes.
you can adduce evidence. Then he goes to the aspect that the inquiry was not properly done.
But lordship,
So what about the evidence which was adduced before the Labour Court?
that was not taken into consideration.
There, where is the discussion with the
Yes.
evidence
Yeah.
regarding the Labour Court?
They have discussed.
Where?
Not, my lord.
Oh, 31 is the only discussion.
Yes.
In our case, the inquiries conducted by the inquiry committee were not based on the charges and the statement of the allegation leveled against the inquiry. There was no formal order from the authority to remove
Yes,
the,
yes.
therefore the inquiries, this is against the inquiry. We are more on the part of the evidence of 3 witnesses.
Yes,
Where is the discussion?
yes, para 2, 3, 4, they have discussed it.
Para 2, 3, 4 of the award.
Yes.
But the finding has to be on the discussion.
Yes.
Finding is more on the inquiry, domestic inquiry. Domestic inquiry, they have failed. There is no dispute. What about the 3 witnesses who had adduced evidence on merits?
Evidence on merit will not there, it is only 2 witnesses.
3 witnesses.
3
One-
witnesses.
One that is Solendra Goswami, that he was the representative of the management,
Hmm.
and the inquiry officer.
Hmm.
Both these witnesses, and no other witnesses regarding this merit. Other aspect, there is no, the Solendra Goswami, his in paragraph 141, his evidence is there. There is 142. The management of I'm reading. I'm presently holding the post of superintendent of agricultural level control. Assam is a registered company. There is the board of directors, and in the corporation presently they are director. They are.
Where is the chief examination? Chief of Sailendra,
142, page 1.
Chief.
Chief is in the record, my lord.
Chief is in the record.
Lordship, so far MW is concerned, the evidence was filed through him, my lord.
No, we have seen it.
Lordship. And with MW2, there is a shift.
If you could page 142.
No, that is not chief. That is cross-examination.
No, cross is 143.
This is chief also 142, cross-examination of Sailendra Goswami. These are all cross-examination. Chief is in the file. Mr. Mohanta will have this today, time may not permit. This will require an examination, your evidence.
Lordship.
If we find that evidence was adduced on the merits of the case, in spite of which in paragraph 31, the Learned Labour Court has only discussed the validity of the domestic inquiry, then you may have a case. But if we find that the evidence in chief of the management witnesses were only on the aspect of the domestic inquiry, which does not appear to be sustainable, then our views may be different.
So basically, my submission is, even if as per Labour Court held that proceeding of the inquiry proceeding not recorded, that will not materially affected, because since they participated and all the opportunities.
No, Mr. Mohanta, you cannot go to that aspect.
Lordship.
If the inquiry proceedings are not recorded.
Labour Court view observation and decision is based on that count, basically. Since even one
Violation of
national justice, that national justice violation has to be decided by the honorable court, my lord, on the standpoint of prejudice, my lord. If there is no prejudice, my lord, where the question of violation of national justice, my lord. That was the law laid down in Lordship State Bank of India, Bank of Patiala versus SK Sarma, my lord.
No, we'll have it, may not be possible today. When, tell us a date.
And moreover, I mean, Cooper Engineering, there is a specific view of the Honorable Apex Court, my lord. If inquiry is held to be defective, there should be an opportunity to the management to adduce evidence in support of the decision of the.
No, Mr. Mohanta, you are not getting us properly. Even if we are not examining the validity of the domestic inquiry, it appears that you have adduced evidence through 3 numbers of witnesses in the Learned Labour Court. And we want to see what are the evidence which you have adduced to support your decision. What is the cross-examination result? And what is most importantly, what is the discussion of the Learned Labour Court? If you find that those were not discussed, then you may have a case without going to the question of prejudice being suffered or not. Mr. Das, tell us a date whenever we'll require some time to deal in this matter. Third, 3M Mohanta Learned Counsel for the petitioner. Also heard 3S Das Learned Counsel for the respondents. Respondents para. Paucity of time will not permit the matter to be taken in its entirety. Para. As agreed to by the Learned Counsel for the parties, placed for hearing on. কেটে দিও 28 তারিখ পাই নেই আছে কিমান আছে বেটা 28 তো সময় লাগিব কিন্তু 28 28
Lordship, maybe part
hard we cannot say. We will hopefully will be there 28 28/7 28 it's a Tuesday.
second
28 July.
Lordship.
Mr. Mr. Dasgupta and Chakraborty, which matter?
Next side.
Some other did. What matter? Again, labor code.
Yes, against an award.
Award for?
Award of reinstatement. My senior is on for the management, I am for the workman. So, my lord, possibly it will not be.
Long.
No, it will be long. But.
Only possible to conclude.
But to conclude it within.
Order of reinstatement.
Reinstatement with that. 17B is operating.
So you are very happy.
Naturally.
The management is also happy with the stay order.
Why?
Because management has succeeded in keeping him out of employment.
But you are getting your salary.
Getting my salary. But
Extra income.
not extra income.
What do you do?
I'm not gainfully employed anywhere.
No. We are not trying to extract anything from you. What did you do?
I was an employee, account section.
Accounts.
Accounts. Well, the allegation is.
What is his allegation? He should not say anything.
No. The allegation that was leveled against me was not what was established in the inquiry. And the reason for terminating or dismissal is something else which has come in the writ petition. So I'll address all these things.
But principal grounds of challenge, Mr. Dasgupta?
Well, actually, here we have adduced evidence on merit as well as on the inquiry also.
Okay.
Now, what here, the learned presiding officer was of the view that the inquiry was not fair.
Okay.
And he has not discussed the evidence on merit. And
Once it is decided that it is not fair, you fall back on the evidence on merits.
On merit.
That has not been discussed. Just like the last case.
That.
Perhaps not.
Anyway.
I'll address my lord.
You will say that it has been discussed.
I'll show it. And in fact, my lord.
Ludbud principles followed.
Yes, Ludbud.
Now, in the written statement, there was no specific plea that they are relying on the inquiry, and if it goes against them, then they should be allowed to give evidence.
Is it required? Not required.
Not required.
No.
In fact, it be on the reverse, it is required. You can make a plea that I want to rely upon the domestic
then only required.
fairness.
Correct.
You can make a prayer. If I fail, I go back. If I don't make a prayer, automatically.
The Ludbud thing is very much clear.
Lud is very clear.
Allah, the lordship fixed a date.
Okay, tell us a date.
Any date.
In the month of August, no?
Okay, same order. Entirely no paucity of time. Will not permit the matter to be taken up today.
18th August.
As agreed to by the learned counsel for the naam likhiye Heard Sri A.K. Dasgupta, learned senior counsel for the petitioner, as well as Sri S. Chakraborty, learned counsel for the sole respondent. That's a paucity of time. As agreed to by the learned counsel for the parties. List for hearing on 11th August, Tuesday.
Yes, no problem.
Mr. Chakraborty,
18th.
11th, what is the problem?
11th I'll not be in.
Okay, then 4th August. Okay.
13th month. 4th, I have 2-3 matters fixed for.
Okay,
hearing.
13th, Thursday, we'll try.
Because 4th matters, 2 hearing matters are fixed. So,
Okay.
there is a possibility of the matters getting clashed.
Aforesaid.
My lordship, I've been told, lordship, Mr. B. Jogo is late, he was in late, so lordship, it will take some time. Let it be on 21st, your lordship.
Take steps to get it released. It is in your treasury. Okay, heard Sri D.J. Das, learned counsel for the petitioner. Also heard Sri D. Gogoi, learned counsel appearing for the officers of the forest department. For para, Sri M. Bhuya, learned counsel appearing for the officers of the finance department. However, pressed for time in view of the fact which was revealed on the last occasion that the money was released directly in the respective treasuries. Full stop. Let specific instructions be taken with regard to the course of action taken for consequent release of the amount to the petitioner in compliance of the order of this court. Para, list on when, Mr. Bhuya? Today is this month. 16. We'll have it on 31st. You give, oh, no, not 27th. You give enough time. 27th,
Can it be lordship, I'm 28, your lordship.
29th,
29th, lordship.
29th.
Lordship,
Only for that purpose, okay?
Yes, lordship.